then point it right here at the QR code. Do you have it? I'll wait a second. When you see the link pop up on your screen, give it a tap. You ready? Boom! Welcome to the Hillsborough County official YouTube channel. We've got all sorts of videos here, all about what makes our community such an awesome place. From local events and community highlights to what's in the perfect Cuban sandwich. We've got it all. We're always adding new things, so while you're here, be sure to subscribe and hit that notification bell so you'll never miss a new video. Here's that QR code again, just in case you missed it. Go ahead and check it out. Ooh. This must have fallen out of that video. This really is the perfect Cuban sandwich.
Good morning and welcome to the March 19, 2024 land use meeting in the Hillsborough County Board of County Commissioners. Would everyone please rise for the pledge and invocation given by our chaplain, Commissioner Cameron Cepeda.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Heavenly Father, we thank you for this beautiful day that you have made, and we will rejoice in it. And we just thank you for this time here today. And we ask you for your special blessing on all of Hillsborough County and our nation. And we just thank you for your protection over all of our military men and women that are serving and all those that are first responders. And we just thank you for your blessing in your holy name, and we ask you to bless this meeting. Amen.
Thank you, Commissioner Cameron Cepeda. Mr. Grady, want to review and changes to the agenda?
Good morning, Commissioners. Brian Grady, Development Services. Along with the published withdrawals, continuances, remands on page 3 through 5 of the agenda, and that would be items A1 through A18. We do have two other changes to the agenda. The first change is on page 12 of the agenda, item E5, initial consideration of HC CPA 24-06, a privately initiated comprehensive plan text amendment of the Energy Industrial Park section of the future land use element to add a residential applicant. The applicant has requested this item be heard as the last item on the E section of the agenda, and the other change is an off-the-agenda item after the conclusion of the BOCC land use meeting. The board will convene as to consider the Environmental Protection Commission of Hillsborough County special meeting to consider Tampa Bay Water's application to the Southwest Florida Water Management District to modify the Baum Farm Water Use Permit. That concludes all changes and continuances for the agenda.
Commissioner Kemp?
Yes, I just want to say that I don't want the agenda numbers changed. I want to have E5 be first, as it's listed on the agenda now, because I think it's relevant to looking at the other two. The first one is the already open, the urban service line has been moved there, and it's 3,300 open acres. And I think we should start to be cognizant of that. There's a request today to put in 2,000 dwelling units, and I think we should deal with that first. It's already inside the urban service area before we start talking about opening the urban service area. So I'd like to just keep the order like it is.
Let me ask Joanna, do we need to remove that from the consent? Does she need a motion in a second, or how do we go about doing that?
That's the issue of the order of
Yes.
the E items. As it is, it's shown in the changes to be changed to that order, and that's the board's pleasure as part of the changes.
Okay.
You can move the changes without making that
Okay.
change.
Commissioner Wostel?
Just wanted a quick point of clarification. We're not, on that item, the way I understood it, we're not voting to approve any homes on it, right? We're just voting to approve that they can go talk to the public more about it. We're not granting them anything. I just wanted to.
Correct.
Okay, that's a huge difference. Thank you.
And
Commissioner Kemp?
I'll just make a motion to move any other changes, but not move that order.
Okay, that's a motion with Commissioner Kemp. Do we have a second?
Second.
Second, Commissioner Cohen. No other comments, please record your vote on the motion.
Motion carries 6-1. Commissioner Wostel voted no.
Okay, before we approve the consent agenda, we have a Tampa Bay Water item B8. They have to give an opportunity for public comment. Does anyone here want to speak to item B8? If not, can we have a motion for the consent agenda?
Move for approval.
Motion Commissioner
Second.
Myers, second Commissioner Cohen. No comments, please record your vote on the consent agenda.
Motion carried 7-0.
All right, so at this time, if anyone's here for a B application, your item's been approved. At this time, if anyone's planning on testifying today, would you please stand, raise your right hand so the clerk can swear you in?
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. You may be seated.
All right, Mr. Grady, on vacations.
Commissioners, the first item is agenda item C1, vacation petition 23-0011. Carry on with the real estate services will present this item.
Good morning.
Good morning, Commissioners. For the record, Carrie Allen, Facilities Management and Real Estate Services Department. Item C1 is vacate ID V230011. This is a petition by MVCA LLC and Falkenberg Capital LLC to vacate a portion of the Mission Village Phase 1 plat as recorded in Plat Book 110, page 321. The petitioners have submitted this request to allow for future site development. In 2022, the board approved a vacating for an undeveloped portion of this same plat immediately south of and adjacent to the subject vacate area as depicted in blue on this map. The proposed vacate area is located south of Palm River Road and north of Estuary Lakes Drive in Brandon and consists of approximately 34,301 square feet or 0.79 acres. Reviewing departments, agencies, and utility providers have raised no objections to the vacate request. Staff recommends approval of this petition request.
All right, this is a public hearing. Would anyone like to speak to the item? Good morning.
Good morning, Commissioners. Brian Dion Johnson Pope, 491st Street South, St. Petersburg. I represent the petitioner. I don't have anything to add that staff covered. I just wanted to make myself available to answer any questions that the commission might have.
All right.
Thank you.
Thank you. Anyone else like to speak to the item? All right, can we have a motion? Motion, Commissioner Kemp. Oh, I'm sorry, ma'am. Please come down. Good morning.
Hello. Hi, good morning. Hi, my name is Nita Clark. I am a resident of the Mission Village community. I purchased my home in 2023. It's 920 Samba Street, June of 2023, basically. So I'm speaking in opposition to this vacating petition by Mission Village because the residents of the Mission Village community were not adequately informed or notified about this resolution to vacate a portion of our community. As I mentioned, I purchased my home in 2023, and since that time, I have received no communication from Mission Village, despite several outreach attempts. In fact, my only notice of this hearing was because Hillsborough County posted a sign in my community about this meeting. I have heard nothing from Mission Village, who has been absentee since I have become a homeowner within this community. I am told by my fellow residents that Mission Village's bylaws, articles, and covenants were changed in 2023. However, I have not received these updated documents since I moved in. I, along with my fellow residents, are frustrated to see that there's a resolution out there to vacate portions of our community when we have reached out to Mission Village communities to try and get answers about changes that affect our community, and we have received no response. We have started having residential meetings because of our concerns about Mission Village's lack of responsiveness to issues within our community. During one meeting, I was informed that there was a covenant that Mission Village can annex and de-annex land. However, there's also a stipulation that they should ensure existing homeowners have access, use, and enjoyment rights of the development we occupy within this community, and that we are not adversely impacted in any significant way. If there's any development being done on these parcels that significantly impacts us, then we should have input about what is going on. We struggle with responsiveness, and we simply request that before this petition is voted on, we be allowed to have more time to reconcile our concerns with Mission Village before it's approved. So our concern is that the Mission Village has abdicated its responsibility, and I fear a climate where Mission Village is able to make such unilateral decisions without getting resident buy-in, without considering how this will impact residents, will lead to continued deterioration within the Mission Village community. So Mission Village has not, essentially I'm saying Mission Village has not done its due diligence. It has not shared the vacating petition with all the residents of the community. As I mentioned, I have not received anything. Everything I got was from a sign within the Hillsborough County posted in my backyard. Again, I am not opposed to progress. I'm not opposed to development. I am not opposed to the sale. I am simply asking that they reach out and contact the residents, get in touch with us, and ensure that we can air out any concerns. We're informed and we're up to speed about what is going on. So essentially, I conclude by simply asking that you guys postpone it, vote against this development, and basically allow them some time to reconcile with the actual members of the community. We have reached out, we requested that, we have received no response. So.
All right, thank you, ma'am. Okay,
And I make a motion to deny.
Hold on, Commissioner Kemp. Anyone else want to speak to the item? Okay, Commissioner Wostel.
I was just going to offer, if he would like to elaborate, I was confused on vacating of, it seemed like you already have pretty large entitlements on the property. You've vacated a substantial portion, like 85% to the south of what you're vacating now. So can we elaborate on some of the things that were just said? Is Mission Village to the west of that lake, or is it? It looked like apartments.
I can elaborate.
Sure.
Commissioner.
Go ahead.
So Mission Village is the entire platted area that included the area that we were vacating, included 3 sets of townhomes, and also included a large tract of land south and east of where we're asking to be vacated. If we can show the map, I would be able to kind of point out where each portion is, but we already had the largest portion previously vacated. So in the blue, that area is all vacated. The area in red is the remaining land owned by my client, VCA LLC. And then the area in yellow is the area being vacated. It is currently completely vacant land. There's nothing that's located in that area. It doesn't have any impact on the townhomes themselves, doesn't create any issues with access. It doesn't create any issues of accessing amenities. It doesn't impact those townhomes. Also, I'm aware of the county's very stringent policies on notice. We went through the notice through obtaining a map from the Hillsborough County Property Appraiser's Office, and we noticed every property that was listed on the map and notice list. So I can't speak to why, Ms. Clark wasn't noticed, but the map that we had contained 7 names that I have in front of me that were all noticed.
So, ma'am, you live in the red?
Yes, I live in one of the red townhomes. Oh, I'm sorry, thank you. Yes, I live in one of the red townhomes. I am at 920 Summer Street. I purchased this home in June of 2023. My name is not on the certificate of mailing. At a bare minimum, like I said, I should have at least gotten notice. I received no notice. I've actually reached out to Mission Village and I requested said notice. I cannot get in contact with them. So again, his own documents support that I have not received any notice. He's saying that there's literally 16 properties there. We've had meetings, we've asked about that. And a lot of these people, it's not accurate, it's not up to date. We're simply asking for the notification so that you can communicate these things to us. To say in front of a meeting, yes, okay, this doesn't impact us. This is something that we can raise our concerns with you personally and resolve this. And then at that point, we can say, okay, no more concerns, fine, go ahead and do this. But we're just saying, we have not received that notice. And so that's why I'm here today. I took off from work to say, you know what? I just want the due diligence done. At that point, if you all of these things, if there are concerns, I would say, okay, go ahead.
Okay, thank you.
Thank you.
Mr. Gormley, what if we approve the vacation of the plat? Like, what does it open up the community to compared to what's already approved? I guess that would be like, what's the negative or positive outcome?
Well, Commissioner, the outcome would be currently in the vacating area. There are 2 blocks of platted townhome lots. Those would be removed. They would no longer be platted lots, and it would remain unplatted land for the vacating area. For the area to the north, it would not affect the areas outside of the vacating area. We have confirmed that access would still be available, and access to the amenity center with the pool would still be available. We had not heard the question about the notice. So we're not able to address that notice question today, but that would be the effect of the vacating.
Commissioner Kemp.
Yes, and I'll again say motion to deny. Based on the testimony that we've heard here today, it sounds like someone who is very engaged and very hard tried to have some kind of conversation or information about this, didn't get access to that. That really concerns me. I heard nothing about this. These things are usually sleepy things that no one says much about. And if there's a vacation, I'm usually very concerned about vacation of public lands, roads, and this is a vacation of a plat. It's not something that we usually hear something like this, but I think it's, it's incumbent to deny this and start some conversation about this is obviously a more engaged and complex issue than we usually get, and I think it's time to see if there can be some more information exchanged here.
Board, if I may?
No, sir, hold off. Commissioner Owen.
Thank you, Mr. Chairman. This is not my district, but Mr. Gormley, procedure-wise, there's a form they have there that basically states that notice was provided to the addresses of the affected or stakeholder parties. What is the procedure involved? Is there any type of public meetings, or what's a requirement for them? I guess I think it's important for us to know as a board.
I believe the requirements are mailed notice, a sign posted on the property, and a legal ad run for the vacating. So those are the 3 requirements. Typically, the notice is confirmed through a proof of mailing. It's something when you bring it to the post office to mail, there'll be a list of addresses and they'll stamp to say these are the addresses to which the notice was mailed. And I believe that's the list that the applicant's representative.
And then we as the county will obviously provide our notice to the public on particular street corners as determined by the county, correct?
Yes, correct.
So I guess what my big question is, if I run into this a lot in the legal world, where certain individuals are trying to communicate with parties, but they don't communicate because the requirement is that they send notice, however it is, by personal service or mail. So I guess I don't want to run us into a situation where we're denying something when they have appropriately followed all of the procedure. But if it is a requirement that there's some type of reach out, like I know in other situations we have a lot of applicants or their representatives, a lot of them that are here today, that do community reach out. Is that something that is typical in one of these when we're vacating rights? Is that something that is normal? Because in a lot of situations, I could see an applicant or an attorney saying, well, I don't have to necessarily comply if the procedure doesn't require me to. You see what I'm getting at? I don't want us to create a situation where there's additional procedure needed by somebody, and I don't necessarily want to deny something. I would not be opposed to maybe if we had to continue it for something, if they wanted to do some type of reach out, but I don't know if it would be appropriate to actually deny somebody if the procedure is not required.
So, Commissioner, you mentioned continuance. That certainly is an option if the board wanted to provide opportunity for the resident to speak with the applicant. It would also give us the opportunity to vet the notice concern that the constituent raised today. Typical, as mentioned here, this is a vacating of a plat, which is not what you typically see. And in the cases where we do see them, like in item C2, it's an undeveloped property with a plat. So this is a little bit of a unique situation where you have a platted development, partially developed, and then part of that plat is being vacated. So most of the vacatings you'll see are right-of-way or easements where it's really a county interest in it as opposed to a community interest.
How soon will they be able to get back to us if we did continue?
The next land use meeting would be April 9th.
April 9th, okay. Okay, and I think I'll make a substitute motion to continue it, just to give the opportunity, consistent with what Mr. Gormley stated as well, for us to also make sure notice provisions were complied with, but a motion to continue.
Okay, we got a motion to continue, Commissioner Owen, second Commissioner Wostel. Commissioner Cohen.
I just want to say I agree with you. Commissioner Kemp, the reason I think it's not appropriate to deny is because it's not on the merits. It's on a process issue, and I think a continuance is appropriate. Thank you.
Commissioner Myers.
I echo the same thing, and I want to thank Ms. Clark for taking time to come down this morning and share your comments with us.
And I don't want to keep this conversation going any longer, but Adam, quick question. I know we're continuing it, but this is clearly a civil issue. Is that even a basis for denial? I know ultimately it's our discretion, but it doesn't sound like that's a legal basis for denial.
What I understood from the constituent is that just looking for information on what was occurring. I can tell you the key issues that we would look at are access, or is the rest of the project being negatively impacted, and we found that it was not.
Okay, we got a motion and a second to continue to April 9th. Please record your vote.
Thank you.
Commissioner Cohen? Motion carried 7-0.
All right, C2.
The next item is agenda item C2. This is a vacation petition 23-0005. Carrie Allen with Real Estate Services will present this item.
All right, good morning. Again, for the record, Carrie Allen, Facilities Management Real Estate Services Department. Item C2 is vacate ID V230005. This is a petition by Simmons Loop Apartment Partners WB LLC to vacate a portion of the estates at Bullfrog Creek Plat as recorded in Plat Book 83, page 25. The petitioner has submitted this request in furtherance of a site redevelopment, which is anticipated to be the new allotted apartments. The proposed vacate area is located south of Big Bend Road, north of Paseo Almar Boulevard, and west of U.S. Highway 301 in Riverview, and consists of approximately 51 acres. Reviewing departments, agencies, and utility providers have raised no objections to the vacate. Stormwater has noted the need to retain historical drainage as documented in a previously recorded standalone drainage easement. This drainage easement will not be affected by approval of this item since it is not dedicated through the plat. Staff recommends approval of this petition request.
This is a public hearing. Anyone like to speak to the item? Good morning.
Good morning, Mr. Chair and Commissioners. Gordon J. Schiff, PA, 4155 West Cypress Street in Tampa, 33607, and I represent the petitioner, and we are respectfully requesting your approval. I'm available to answer any questions and reserve my time for any rebuttal. Thank you.
Thank you, sir. Anyone else like to speak to the item? Can we have a motion to
Move approval.
motion to approve? Commissioner Owen, second Commissioner Myers. Please record your vote.
Motion carried 7-0.
Okay, thank you. Next item.
Next item is agenda item C3, vacation petition 23-0009. Carrie Allen, Real Estate Services, will present this item.
Right, for the record, Carrie Allen, Facilities Management Department. This is a petition by James S. Eggert and Cheryl M. Eggert to vacate a portion of a 15-foot wide platted public utility easement lying within Lot 8, Block 3 of the plat of Holiday Hills Unit Number 3, as recorded in Plat Book 43, page 85. The petitioners have submitted this request to allow for the installation of a shed into a portion of the utility easement. The proposed vacate area is located north of Bloomingdale Avenue and east of John Moore Road in Brandon and consists of approximately 3,944 square feet or 0.1 acres. Reviewing departments, agencies, and utility providers have raised no objections to this request. Staff recommends approval of this petition request.
This is a public hearing. Anyone like to speak to the item? Good morning, sir.
Good morning. I'm James Eggert. I'm the petitioner, and I'm here to ask that you please approve our request, and I'm here to answer any questions if you have any, and appreciate your time. Thank you.
Thank you, sir. Anyone else like to speak to the item? Can we have a motion?
Move approval.
Second.
Motion, Commissioner Owen, second Commissioner Cohen. Please record your vote on C3.
Motion carried 7-0.
Okay, thank you. Right now on the public hearing agenda, Mr. Grady.
Commissioners, the next item is agenda item E1. This is PRS application 24-0102. This is for a minor modification to a single-family lot within the Bloomingdale subdivision. And again, as shown here, there's a single-family subdivision. The request is to add an accessory dwelling to the lot. The accessory dwelling would be 195 square feet. As part of this request, the applicant is requesting a reduced setback on the rear property line to 6.89 feet, whereas the accessory dwellings are required to meet principal structure setbacks. Given the small size of the accessory dwelling, which would be comparable to accessory structures, which would be permitted to have a 3-foot setback. Staff has no objections to the reduced setback for this accessory dwelling and is recommending approval. We're available for any questions. Thank you.
All right, thank you. Is the applicant here?
Valerie Shar from the owner.
So David Zink, Distinctive Design Homes. I'm the contractor.
Would you like to make any comments or?
No, we're just here to ask you to approve and answer any questions if you have any. We appreciate your time.
All right, thank you. Anyone here in support of the application? Anyone in opposition? Commissioner Owen.
Thank you, Mr. Chairman. And Mr. Gormley, this is extreme. I had 175 foot, but it's 195 square foot dwelling on this one.
Correct.
Okay,
Yes,
extremely small structure here.
Very small, yes, sir.
Move approval.
Second.
Got a motion to approve. Commissioner Owen, second Commissioner Wostel. Please record your vote on E1.
Motion carried 7-0.
Thank you.
Thank you.
Next item.
The next item is agenda item E2, PRS application 24-0104. This is a request for minor modification to a 1.03 acre parcel that's located within the Summerfield development that's located northeast of Big Bend and 301 on Summerfield's Crossings Boulevard within the commercial portion of the planned development. The request is this project is a permitted minor auto repair. The request is to add the ability to remove engines and transmissions with repairs off-site. Staff reviewed this and finds this request would not have a significant change in the overall operational characteristics of the project and therefore finds it compatible and is recommending approval. And we're available for any questions. Thank you.
All right, is the applicant here? Good morning.
Good morning. Drew Morrison with Chastain Skillman, Civil Engineers, 205 East Orange Street in Lakeland, Florida. Here for any questions if the board has any.
All right, thank you. Anyone here in support of the application? Anyone in opposition? All right, can we have a motion?
Move for approval.
Motion, Commissioner Meyer, second Commissioner Cohen. So no comments, please record your vote on E2.
Motion carried 7-0.
Next item.
Commissioners, the next item is agenda item E3, PRS application 24-0112. This is a minor modification to a plan development located on the north side of Bloomingdale Avenue, west of the intersection of Bloomingdale Avenue and Providence Road. The request is to modify conditions regarding approved design exception that was approved as part of the original approval. As part of that original design exception, there's provisions for a mid-block pedestrian crossing across Bloomingdale to access a bus shelter and bus stop on the south side of Bloomingdale Avenue, and also a commitment to provide for the funding of a crossing guard associated with that mid-block crossing. In lieu of that, the request is to provide for, and this change is to remove the requirement for the mid pedestrian crossing and the crossing guard. In lieu of that, they would provide for a bus stop on the north side of Bloomingdale Avenue. Staff has reviewed this, and based on agency comments received from Public Works, Sheriff's Office, and the School Board regarding the current required improvements, staff is recommending approval, and we're available for any questions. Thank you.
All right, is the applicant here? Morning.
Good morning, Cammie Corbett with the law firm of Hill, Ward, and Henderson this morning. We are asking for a modification to these conditions. Commissioner Kemp, you may remember this application way back where we had committed to doing some pedestrian improvements to try to improve Vision Zero in this area and also to facilitate transit ridership in the area. But unfortunately, after talking with Public Works about the mid-block crossing on Bloomingdale, we don't think we would ever have enough pedestrians to warrant a mid-block crosswalk there, and so that's not practical for us to do. So in exchange for that, we had a bus pad originally there, but we are actually moving forward with a shelter on our side in conjunction with HART. And then also in conjunction with the school board and the sheriff, they were not interested in a crossing guard at Bloomingdale and Providence. And while these are well-intended pedestrian improvements, actually the phone calls that I received, people were very supportive of this because they had concerns that a mid-block crossing and a crossing guard along Bloomingdale would actually interfere with traffic and cause more problems than the pedestrian information. So with that, we'd respectfully request your approval and here to answer any questions.
Anyone here in support of the application? Anyone in opposition? Commissioner Owen.
Thank you, Mr. Chairman. And the letters we have from the sheriff and school board, obviously we have a big charter school on the other side of the road there in Winthrop, which is obviously the major concern. But the correspondence we have basically state that as far as safety measures goes, the sheriff sees no issue with this. They're providing a bus stop on the other side, which works and helps for transportation. I would agree this road, commissioners, is an absolute nightmare in the morning, and especially this particular area. So I'd just like to confirm for the public purposes that the sheriff and the school board have both confirmed that a crossing guard is not necessary at this point.
It was confirmed, yes, sir, confirmed by both that there was not a need for a crossing guard there, regardless of the funding from the applicant. It was not something that they felt needed to be provided in that location, notwithstanding the funding obligation.
Yeah, and I think that's important, notwithstanding the funding obligation. So it's not like they were just saying we don't want to fund a crossing guard. They're basically deeming it not necessary. So I'll move for approval.
We got a motion approved. Commissioner Owens and Commissioner Wostel. Commissioner Kemp.
Yes, I just want to have a little information on the record because I am concerned about this. And if we could just put up a map of where this is and the nearby intersection at Providence and Bloomingdale. I know we had that map in our backup. Do we have a better map that actually shows that nearby intersection? So, and I guess from the where the crossing would be to Providence Road is, and I looked into this a little, about a sixth of a mile. And as was stated, the Winthrop Charter School is on the south side of that. That Bloomingdale Road is a kind of a nightmare. And I was very concerned because I think, and I didn't confirm this is to my memory just a few years ago, we had, I believe, 6 pedestrians that were killed in this area trying to cross in 2 different incidents, I think, at least. And it's just incredibly concerning to me that this is a dangerous condition. And as I understand, our staff, is this, if you could just give me information about this. So our staff is the one who looks at this and looks at the possibility of a mid-block crossing here and the need for it. And can you tell me what we have, just what our decision was about that, our traffic
Yes,
staff?
it was determined, Commissioners, that the mid-block crossing was not warranted by volumes and was therefore not something that could be supported at this time as going in, as it didn't meet the minimum threshold to provide that mid-block crossing.
And so the mid-block crossing is done by the population that exists now. Is that accurate?
I believe it's a volume, is it volume-based?
Yes, maybe we could get that answered.
Hi, good morning, Commissioners. Josh Bellotti, Engineering and Operations, Public Works. So yeah, some of the warrants that they would look at there, in addition to looking at the context and classification of the roadway, speeds, volumes, would be things like volume of pedestrians, volume of vehicles, things like that.
So with the volume that is now exists, because what we're adding here is 472 units, I assume, probably with children that may indeed try to cross that road to go to Winthrop. And a sixth of a mile, they would walk down a sixth of a mile and over. I guess that in that case, I guess it's actually at the other side. But there is a lot of attractors to cross the road all over the place. And people tend to not necessarily walk a sixth of a mile down for the safest route. There's no pedestrian island there. And I'm sure that road, like kind of my experience of Florida Avenue, is that it's congested sometimes, but sometimes there's lots of traffic speeding through there. And I'm just really concerned about eliminating this crossing walk. I'm also concerned about having it because of the area it's in. I'm wondering about some other possibilities. First of all, re-looking at this for a warrant when the population changes. I'm very concerned about future actual deaths and extreme injury in this area due to this decision. I'm wondering also about the intersection at Providence and Bloomingdale. Can we make no right on red turns, some things like that? Because I do think we will have increased pedestrian use. Right now, there's nothing there. And I'm just very concerned about what kinds of mitigation we do if we are not having this mid-block crossing, what we do to make that safer for all the possible pedestrians that are going to other places at that very dangerous area. Is there any, I mean, can we, is there anything we can do about like no right on red, some kinds of mitigation that we can consider here? Can we reconsider this in a couple of years? I'm just not, I don't think that will happen, but I just need to express that because I'm very concerned about the condition and what we're subjecting people to.
I just want to add anything before we move on. Anything else?
Just to note that we Just note that we did recognize that intersection of Bloomingdale and Providence was a controlled, signalized intersection, and we were comfortable that that would be a safe way to cross the road at that location, given the lack of volume to support the mid-block crossing.
Okay, and as you stated, the school district and sheriff both oppose crossing guards there.
Correct. Neither was amenable to providing a crossing guard there, again, notwithstanding the funding coming from the developer.
All right. Okay, we have a motion and a second. Commissioner Owen?
Yeah, and I just want to, we're talking about too, as far as the crossing guard for children, for school purposes, correct? For walking, or was it just, yeah, so I want to make sure we're talking about the right issue here. And as far as the residential property, we have one set of townhomes off Providence, probably across from Providence Baptist Church there. I don't think it's a large community. And then I'll tell you one way we can stop having the issues on Bloomingdale Road is stop approving super high-res units on this road when the traffic is unbearable. But to slow traffic down on Bloomingdale, we have to be very cautious. And where Winthrop Charter School is located, it's not in the Winthrop. It's technically the Winthrop Village, but it's on the very, very back side of children walking and traversing to and from that school. That I think, what's the highest grade it goes to? Do we know that offhand? It's not. 12. It's kids, yeah. Yeah. So I think from what my understanding is there wasn't enough children walking to and from school to warrant the crossing guard is kind of what I'm understanding. Is that kind of what you got from the correspondence?
Yes, and in the current condition, the analysis of that location is there was not sufficient volume or traffic, kids walking to school or otherwise, to warrant the mid-block crossing.
Great. I think that's good for clarification. Okay, thank you.
All right, we have a motion and a second to approve. Please record your vote.
Motion carried 6-1. Commissioner Kemp voted no.
All right, next item.
The next item is agenda item E4. This is PRS application 24-219. The request is for a minor modification to a plan development that's located on the Pasco County line on the west side of US 301. This is a PD as a planned environmental community. The request is to make a number of modifications to some of the development standards and also some of the uses. Particularly, there's a requirement for a minimum of 200 units be for housings for older persons. The applicant is requesting that be removed. Staff, that is not a requirement of the community of the comprehensive plan policies dealing with the planned environmental community, nor was it a requirement of staff during the original rezoning. They're also looking to modify the timing of the construction of the internal community park that's serving the residents, requesting increases in building height for both residential and commercial, and modifying the units per development pod and also some of the internal circulation layout. Staff is recommending approval, and we're available for any questions. Thank you.
All right, is the applicant here?
Good morning. Cami Corbett with the law firm of Hillward and Henderson, representing the applicant Eisenhower Property Group. Staff went through the changes. They're really design changes. This was approved for rezoning back in 2007. We're now to the point where we're designing and developing the community, and it made some minor changes. We're not increasing any number of units, and we're not having any external impacts. So we're here to answer any questions you might have, and we respectfully request your approval.
All right, anyone here in support of the application? Anyone in opposition? Can we have a motion?
Second.
Motion, Commissioner Wostel, second. Commissioner Myers, please record your vote.
Motion carried 7-0.
Okay, thank you. All right, the next item, I believe, Planning Commission will introduce it. Melissa?
Yes, sir. Thank you. Melissa Leinhard, Planning Commission staff, for the record. Within the procedures manual for plan amendments for unincorporated Hillsborough County, once a privately initiated text amendment to the unincorporated Hillsborough County Comprehensive Plan is applied for, Planning Commission staff must schedule the item for what is called initial consideration at a meeting with the Board of County Commissioners. That is this meeting today. So we're here based on a board-initiated change as part of the procedures manual update that started in 2022 and was ultimately approved in the beginning of 2023. So this is a very new process and one that you all have only seen one time. You saw this back in September of 2023 as part of the first Energy Industrial Park privately initiated text amendment, which you all allowed at that initial consideration to move forward, and that is in process right now as part of the April cycle of plan amendments for this year. But that being said, this first item is for another energy industrial park privately initiated plan amendment. I also wanted to point out, and for something to keep in mind, that this is just the initial consideration. If allowed to move forward, this item and the subsequent two items, which I can mention again during those introductions, they will still go through the typical public hearing process. So you will still see them as in your workshop, and you will still see these items as part of a transmittal hearing, and then if they're transmitted, you would see them for adoption. And the same goes for the Planning Commission. They would also have a briefing at the Planning Commission and also have one public hearing at the Planning Commission. So this is not a substitute process. This is an addition to process. So the exact language in the procedures manual that applies to the memo before you today for this item reads that Planning Commission staff is to prepare a report that shall include at minimum the following information: a determination of resources needed for adequate review, a recommendation on the timeline to review the amendment, a recommendation on additional public outreach to be conducted by the applicant beyond what's required by the procedures manual. So with that being said, I'll dig in a little bit into the request. So this request here with HCCPA 24-06, again, it's a privately initiated text amendment to the comprehensive plan, most particularly applying to objectives 58 and 59 in the future land use element. The applicant is requesting a change in a particular area of the energy industrial park. And with that, Jillian, if you don't mind, she's going to pop a map on that Elmo so you all can see the exact area we're talking about. But the applicant, well, first, the energy industrial site is located, in the eastern part of the county, south of State Road 60, generally between Dover Road and Turkey Creek Road and north of Durant. The southern edge is not perfect. But the area in question today that would apply, that the proposed text amendment would apply to, is the crosshatched area. So it's essentially the southwest area of the site that is beyond the CSX railroad line. And what the applicant is asking is to add a residential option to this area. Right now, there is no residential option in the energy industrial park. It is for energy producing uses first, and then the other uses that would be allowed are some commercial and industrial uses in certain areas. The energy industrial park as a whole did go through a rezoning in 2010, so there is a certified site plan and associated conditions of approval that Adam and Brian could probably address later if there's some questions about those. But essentially, this area is about 475 acres. And what the applicant is requesting is to go up to 4 dwelling units per acre in this area. And again, this is not a map amendment because the text in the plan particularly applies to this only geographical area, energy industrial park in the east part of the county. I believe Commissioner Kemp mentioned this before, but I'll just reiterate it for the record. With 475 acres and up to 4 dwelling units, a total of approximately 1,900 dwelling units could be considered for just this crosshatched area here. And then as far as the memo is concerned, addressing those 3 requirements that I outlined previously, the resources needed for adequate review. We have everything detailed in your backup, and I won't go through them line by line, but just calling out a few items. We have asked for a report addressing the compatibility of the request with the surrounding land use pattern. We've asked for an analysis on the current renewable energy production market as related to this application. We also have asked for some information on how the remaining area, not subject to this particular text amendment, would be able to address the goals of renewable energy production and the other objectives and policies under this section. Then secondly, regarding the time frame, Planning Commission has determined that the recommended timeframe to review the amendment would be once everything is sufficient and the additional community meeting occurs, then the item could be scheduled for a plan amendment cycle, very much like the previous EIP amendment that you all saw back in September. The other thing I wanted to mention, that if the board so desires and directs a concurrent major modification of the existing plan development, which is 10-0692, that could also be part of that process, but we would need board direction to do that. The last thing is about the public outreach. We are recommending, as I just mentioned, an additional neighborhood meeting above and beyond what is required by the procedures manual for map amendments, which is, there's one required in the procedures manual today, and then we would ask for one additional neighborhood meeting. We are recommending the applicant mail notice for that meeting. And in addition, we are also going to be sending out, and by we, I mean Planning Commission staff, we did this for the previous, or the currently in cycle EIP Amendment 2315. We're going to send a courtesy email blast to the Valrico Community Plan folks. They ask a lot about this site in their meetings, though it is not part of Valrico's community plan boundary. Planning Commission staff felt it's appropriate to keep those folks in the loop, and there's a lot of overlap there with those ideas and involvement. So we're going to go ahead and send an email blast with the information where the meeting is, what time it is, and all those sorts of things. We're also requesting a sign-in sheet as well as a meeting summary be submitted to Planning Commission staff. And then we're also going to ask the same thing that we did for the other EIP amendment regarding signage. Though this is not a map amendment, it sort of acts like a map amendment because it applies to one geographical area. So we're asking for signs at the corners, basically in each quadrant, so everyone knows what is happening and when those community meetings are. So essentially at this meeting, there are two choices for you according to the procedures manual. You can make a motion to take no further action on the application, and then an 80% refund is given to the applicant. The other option is to have a motion to allow the application to proceed for review and the public hearing process associated, located in the, the process associated with the procedures manual and outlined in that document. And with that, I'm here for any questions.
All right, great, thank you. Applicant here, each representative has 3 minutes. Good morning.
Good morning. If we could go to the overhead, please. Jake Kramer, 401 East Jackson Street, number 2100, with the Stearns Weaver Miller Law Firm. The commissioners, I just wanted to show a couple of graphics, please, if we could show that on the overhead.
Don't touch it, don't touch it.
Okay, sorry. Sorry, staff did a good job of introducing our item. We're in full agreement with the recommendations on community outreach, community engagement. We've actually already reserved some times and places for those meetings. We're just waiting on your approval to be able to do that and notice those. We've also reached out already to some individuals who have had questions for us about this application. What I wanted to show on this graphic is that we think that it's time to introduce residential to the energy park. As you all know, this has been around as a concept for a long time, and for various reasons, it hasn't been able to get off the ground. So what this graphic shows you in yellow is the energy park in relationship to the vote you all took a couple of weeks ago to consider expanding the urban service boundary and how close it is to those areas. What this graphic shows is on the left-hand side in the blue, that is my client's ownership. There are two owners of the Energy Industrial Park. What the interesting thing about this graphic is I think it helps show that this property actually is going to act as a bridge between Valrico and the county's growth east, toward the east, and Plant City. You can see we're almost touching the Plant City vision area where Plant City is going to grow to. And these areas are projected to grow over the next many years. The yellow here is the only portion of the property that we will be asking you to consider residential for in the future. And again, this is going to be suburban density, no multifamily, but we do believe now is the time to turn this into a true mixed-use project to act as that bridge between the Eastern County and Plant City's growth to the south. So with that, we're here. Our full team is here. We realize we're not here today to get into the substance, but our team is here in case you have any questions. Thank you.
All right, thank you. This is a public hearing. Would anyone like to speak to the item? Okay, what's the pleasure of the board? Commissioner Owen.
Thank you, Mr. Chairman. And yeah, this is obviously in my district. We've worked really hard on the Valrico Community Plan, and we did leave this portion out because it's such a unique section. And Melissa, comment again. So these would be, if approved, and we're not approving these final, these would be limited to a Res 4, correct? In this particular, up to a Res 4.
Yes, sir. It wouldn't be designated as residential 4, but essentially, yes, they could be considered, per the text that's being proposed by the applicant, privately initiated. In this area, the text would reflect that they could be considered for up to 4 dwelling units per acre, which would also include 4 units per acre. So definitely mimicking Res 4, it just wouldn't be designated as Res 4.
Yeah, and I think the argument for the future of this energy park would probably be for another meeting. I know this is not a regular meeting. Mr. Gormley, I discussed with you that probably in the next meeting I'm going to bring something forward that full presentations come to the board on the energy park, where we're at, so that this board can really even take a look at to see the feasibility of an energy park in this particular area, because I see more and more of this coming in the future. I obviously have a huge issue with growth in my district, especially in the South County area, and we have to find other areas to develop. But we want to be very careful how we do this, obviously, because we certainly don't want to see high-res units going up in the Valrico area. It's one of the main reasons that we brought forward the Valrico Community Plan, and maybe if the energy park, for whatever reason, does not work out, we could possibly include that in the Valrico plan in the future, because it is Valrico. I wonder what we could do in the future. And maybe, again, these are discussions for another day. But just so the board knows, I know that we may want to get into an in-depth conversation today, but I think the appropriate time from talking to Mr. Gormley would be in a regular board meeting to probably bring a future item on this so that we can make some future decisions on the future of this energy park. But where we're at now, I think that obviously, I'm going to move to authorize staff to allow the amendment to proceed for review, and so that the applicant can begin outreach by recommending a plan. And again, I think that this discussion on the future of Energy Park we have got to have as a board, because development is heading that way, and as we push the urban service area back, it's in between Valrico, or excuse me, Brandon and Plant City. So we definitely need to have a discussion as a board as the future of Energy Park. So thank you.
All right, we have a motion by Commissioner Owen. Do I have a second?
Second.
Second, Commissioner Wostel. Commissioner Wostel.
Yeah, I just, again, I think you tried to clear it up earlier, Ms. Leinhardt, but your words are maybe more sophisticated on the issue. We are not approving, it was said, but we are not approving anything more than allowing them, the owners, to express their First Amendment right to go talk to people and bring it back to us and petition their government. That's all we're approving. So anyone that's up here screaming democracy, there's no way that they could ever not support this, which is us empowering a citizen that we represent to express their First Amendment right and to petition their government. We're not saying that we're approving anything, correct?
That's correct. Yes, sir. No
Now,
problems.
on this property, we heard that there was a PD in 2010. I don't know the history. I've seen some of the submissions to the record that there's an environmental issue in this process. Can we require them to make go above and beyond whatever the history of this phosphate mine is? Are those things that are going to be covered? And
So, Commissioner, there is an existing planned development zoning on the site. If this amendment moves forward and is adopted and sought to make a change, there will be a required change to the plan development to enable to implement the plan amendment.
So what is this land already entitled to?
It is currently entitled for approximately 7.3 million square feet of building area, of industrial, warehouse, commercial uses, as well as energy producing uses. And that's the primary purpose of of the category as created was to support energy-producing uses.
So everyone involved in this process understand it already has millions of square feet of approved buildings on this site. So I think that that's an extremely important variable for everyone to understand as we move forward back 14 years ago. So thank you.
Commissioner Kemp.
Yeah,
I didn't hear you when you asked if somebody wanted to speak, so would like to be given a chance.
Sure. Yes, sir.
that's exactly, actually, I was going to first ask about Mr. Neiman.
Okay.
And if it's, because I,
Please come forward.
I'm sorry, I don't hear too well. My name is George Neiman. I live in Dover. I live next to the Energy Industrial Park. That section of land was supposed to be set aside for renewable energy. And it looks like the owners don't want to do renewable energy. But if that's the case, they should sell the land to somebody who wants to do it. But there are locals that have lived in and worked in the area of that former mine. They talk about dumping of contaminated waste all over the mine property, not just in that Superfund sludge pond. We have a local resident that we spoke with that worked for the county as a plumbing inspector. He says that he's seen instances where they dump, and it's not the Superfund site, it's all over. There's contamination there. We submitted, I'm with the coalition, the Fix Hillsborough Neighborhood Coalition, and we submitted a letter to the county and the Planning Commission. We haven't heard back. Nobody got back to us. But we've had an expert look at the records, and there's a lot of uncared for problems with new emerging contaminants. And this application, if you approve it, we believe that it opens the door for residential, the next project. Maybe they'll just have to do a rezoning. They won't have to do a text amendment. They'll come in. Where will the next residential enclave be? Will it be within 30 feet of that 9.5-acre Superfund site? You will lose control. And don't forget, the EIP, that's 3,000 acres. You open it up for other residential on that 3,000. And we've been to 2 community meetings for the other one, 2315. And what we found is no one is interested in letting this go forward, particularly residential. They're against the first one, and now we've got this second one for residential. And they lined up to sign petitions against it, which we'll supply eventually. We'll give you a stack of petitions. The community doesn't want it. I want you to know that no one's against people making money. These speculative landowners bought it. It's problem land. You look at other former phosphate mines like Tenorock in Lakeland. It's land that can't be used. And it's unfortunate that it can't be used, but there's too much contamination risk. And they mentioned building daycare centers. Do we want 1,900 homes to?
Thank you, sir.
Okay,
Appreciate your comments. Commissioner Kemp?
yes.
May I respond?
Not right now, no, sir.
To Mr. Neiman's point, we have heard nothing about this in terms of this land and the condition and shape of it. And I am first wondering, maybe Adam can address this. So what, in terms of that, and also Ms. Leinhardt, because I've asked before for some kind of delineation about the former phosphate land. And what is the status of the land and who is responsible for determining that, or, do we have anything in place with regards to that?
So, Commissioners, if the project were to move to development stage, we would work with both EPC and the environmental division within the county to address any kind of need for remediating the area being developed. I don't have specific information on the Superfund status, but that is something that would be looked at as part of the development process of the site, both with county staff and EPC staff.
At what point?
At the point that the project would come in for development, so right now it's zoned, so if it were to come in to develop today, that's something that we would look at as part of the permitting process for the zoning. If this amendment is approved and the project seeks a rezoning or modification to its existing zoning, that's something that we could provide information through that process as well. It would be less detailed than the permitting documents, but certainly could provide a overview of the condition of the site as best, based on the best information that we have.
And Ms. Leinhardt?
Yes, if I may, I would also like to point out that during the plan amendment process, we do send out agency review summaries, so we do get agency comments back, and we would anticipate, because this is a proposed residential use, we would anticipate some comments that would address that.
I also would like to address the fact, I was, around in 2011, I believe it was, when this first came here. And at that time, the Energy Industrial Park, there were many people, including, I'm thinking Mr. Neiman, but in fact, they said that they were doing 2 energy industrial parks, and that would be done first before anything else was put on that land. That was the first condition that was actually removed about a year and a half ago or 2 years ago, that they had to do 2. They still have to do 1, and it was always predicated to be the first one. We've got another, if you could just explain this, because I think it's confusing.
Sure, I can help with that. There was, I think it was about 2 years ago, maybe 3 years ago, there was a plan amendment, text amendment change to the EIP language that, again, there were 2 renewable energies required in the text that was adopted in 2010. One of the applicants that applied, one of the property owners applied to change that language to have, they have to have the same output, but that they could only have 1 renewable energy rather than 2. That change was made, it was adopted by the board, and that language is in effect. The second request is one that is still in process today. It, again, is part of the April cycle of plan amendments, so you all will see that later this summer, early in the fall. But that one is to essentially, instead of requiring the renewable energies first, it would allow for some industrial and commercial uses to go in first instead. And that, again, is not decided. That is still, it was initially considered by you back in September, and they've held their 2 community meetings. Now it is officially in the plan amendment cycle, but no decisions have been made. You all have not heard that as part of a briefing, a workshop, or a public hearing at this time.
Would they also be able to do then this residential first?
With the plan amendment 2315 that's currently submitted, no. They specifically have asked for commercial and industrial uses ahead of renewable energy, but this is this request today, 2406, is the first request introducing residential to the property.
Right. And so I think it's very important. This, first of all, I never ever even took it seriously back in 2011. I wasn't a board member here, I wasn't a staff member here, but I thought it was always just a proposal put forward that wasn't a serious proposal. It was only done to break open the urban service line at that place, and that that was never the true intention. And so I'm not surprised that now down the line we're getting all these changes 15 years later about what this land would truly be used for. As you can see on Google Maps or from some of these pictures, this land is totally open land. It's 3,300 acres that have not been developed. They're talking about, in this PD, about doing just about 6 of that acreage, actually less than 6, is some 478 acres at 4 an acre. So we are talking about 1,900, homes, individual homes. And if you want to talk about putting a bunch of traffic on the road down there, that actually doesn't even have roads and is just, everything is substandard. Nothing was planned. at this point anticipated to have residential on this huge undeveloped area. And we're only talking about one little part of it here. We're also talking about putting it next to railroad tracks, considering the issues we've had with that lately. But what I'd like to do is I've asked, and just looking at the big area, because it's 3,300 acres. Before we had someone who had come in and said you could develop a new Temple Terrace on top of that, if all things considered, if that would be possible. It'd certainly be possible to put far more dwelling units on that. If we could, I just asked about what is anticipated there in terms of roads and connections, and I wanted to know, my thought was about this and access for roads. We've talked about, put roads in before development or make some kind of, do that. Well, what do we have here? If we could just put up the map for anything proposed in that 3,300 acres for right now, any kind of plans, any kind of set aside of, for a continuation of the grid, the big grid in that area?
If it would be helpful, we brought the corridor preservation plan,
Yes.
which is an adopted map in the mobility section of the comprehensive plan. It was updated lastly in 2022. There were no major corridor shifts in that change or in that update, but it is my understanding that Hillsborough County Community and Infrastructure, their department, they're working on an update to the corridor preservation plan in conjunction with Planning Commission staff and other county staff. Jillian's going to zoom in on the Elmo here. So the only changes that are shown today is State Road 60 going to 6 lanes. And then if you can see kind of that small black, that's Lumsden. So it's a small extension that would connect to Dover Road. But that's all that's planned today, like surrounding this exact subject site.
And that's just in corridor preservation. That's not even in anything else except to say that's a plan. So we have this 3,300 acres there. You can see it right there, below Brandon Boulevard, above Durant Road, with Turkey Creek on the one side. And you can see even the inadequate grid that we have at that point there to the west. And I think everyone would agree we don't have a strong enough grid or connectivity in the Brandon area, and that is why in Valrico and Riverview, that's part of the reason we have these issues is we don't have any access, we don't have the infrastructure there. But as you can see, this big area in here that we're talking about developing right at this moment has also not even preserved corridors, not to mention actual roads and plans. That's not there. And yet we're talking about moving this ahead. We have all these other questions about this area. And this, by the way, is already the urban service line has been moved. And the reason I went to this first is to talk about this before we even talk about opening up the other areas, because this is a serious infrastructure issue. Again, 1,900 dwelling units in this one little part of this. And I would totally expect, we heard, this is the only place for dwelling units. Now, this is the way it happens. First, it wasn't supposed to be any. Now, all of a sudden, there's 2,000. First, it was supposed to be 2 industrial parks. Now and they were supposed to be built first. Now we have 1, and we're trying to postpone and not have that. I would love to see, 100 acres out here at least start to be used for solar to power and give some relief to our grid and resources out here and have that come first. That's another item.
All right, Commissioner, we got other commissioners in the queue.
I'll
We
just,
need to
I
round it up.
wanted to say what this was, but I'll be voting no as we move forward because I don't think we're ready yet.
All right, Commissioner Cohen.
I think it's an excellent idea to go ahead in a regular meeting, Commissioner Owen, and have all of us get some background on how this came to be. Commissioner Kemp, I can understand your skepticism over how this would work 10 years ago, because it clearly hasn't attracted much interest in the time that's passed. How is it actually zoned right now?
It is actually zoned as a plan development zoning. It's got conditions of approval and a site plan.
And it has commercial entitlements inside the PD?
It has some commercial entitlements, yes.
So how does that, would this property qualify under Live Local?
Well, I think that's another discussion. I think we'd like to bring that back. I want to make just clarify one of the items that was said. This area is an expanded urban service area, but it is energy industrial park urban service area. So it's not urban service area just like any other. So how that would interplay with a use that's not contemplated by that zoning and by that urban service boundary expansion is something that we are looking at. There certainly are commercial entitlements there. I think there's a real question of whether whether something operating outside of the zoning and outside of the comp plan, given the way this area is designated, could have utility lines extended to it. I think it's a different question here than it is for in the typical urban.
But this would all have to be examined in this
Yes.
in this process.
Yes, sir.
You know, I took the comment about all we're doing here is opening up the discussion seriously. I mean, there are a lot of hurdles that would be involved in doing something here, and it might very well be that there's a lot of reasons that we would decide that we didn't want to allow it, but there are also reasons we might decide that we want to allow it once we look through, because we don't know the answers to some of the questions related to what else could happen to it given the new state of the law.
Yes, sir.
You know, so you know, I think this is a very, I understand the concerns about what we may be unleashing here, but the only way we're going to sort of get to the bottom of what to do is to have some kind of a process. And if people are against it, they'll come out and say they're against it, I'm sure. And those public meetings will reveal how the community feels, and we'll have a lot more to go on later. So my inclination is to go forward, but with a lot of caveats that this is, you know, going to take a lot of study, and it may ultimately not be the right fit, but we're not going to know unless we examine it.
Thank you. Before we go around again, I just want to say Commissioner Cohen and Commissioner Wostel are correct. What I heard Melissa say, and I wrote it down, initial consideration as part of a new process. This is in addition to, not a new process. And then she went on to say, and we're going to require an additional meeting. So there's certainly going to be a thorough vetting process throughout this. Commissioner Wostel?
Yeah, exactly. And as for 2010, I don't know. I was deployed against radical Sunni terrorists in Afghanistan, so I can't speak to what happened there with the rezoning. But a lot of discussion was about the grid and mobilities that routes. But I have to imagine that with millions of already approved square footage of buildings on that area, that would entail substantial mobility/impact improvements to the surrounding area to facilitate millions of square foot of industrial space. Is that fair to assume?
There are currently operational improvements that are required to access the site. They are in the vicinity of the project. They will also be subject to mobility fees, which would be commensurate with the scale of the impacts that would be used to fund infrastructure to support the project.
Because that large of a facility, I can't imagine the amount of freight that's going to be going in and out of there. I mean, you want to talk about disruptive to the area compared to regular vehicles, and I think that's all variables that I think some people don't like chicken coops, and they deserve to come and talk to us about it, and so do these folks. So I'll rest. Thank you.
All right, Commissioner Owen.
Thank you, Mr. Chairman. I'll be fast. And Commissioner Cohen, my questions as Live Local, I've asked those and labored over those with Adam smiling. So that's something that we're collectively going to have to get more information on as well and make sure we're making the right decisions. And Commissioner Kemp, as to why folks, why the prior boards may not have used impact fees timely and put the roads before development. I can't really answer that question, but what I can answer the question to is, as I completely agree with you on that we need to make sure that as we move forward with just development in general, whether we're throwing up boxes with 1,000 windows or whether we're doing suburban neighborhoods, we need to make sure that our roads and infrastructure are taken care of. My side of town is a perfect example of how it hasn't been. So what this is, and I think Mr. Chairman, you reiterated it, Commissioner Wostel and Commissioner Cohen, you labored over it as well, is that we are basically authorizing staff to allow the amendment to proceed for review and begin the outreach for planning. So that is what this is today. So for the public purposes, they're going to have plenty of opportunities to opine, and this is just beginning that process. So thank you.
All right, we got a motion and a second. Please record your vote.
Motion carried 6-1. Commissioner Kemp voted no.
All right, E6.
Thank you, Commissioners. Item E6 is also another initial consideration item. This is one memo covering 3 separate privately initiated text amendments. They have separate applicants, and I believe that they are all here today and would like to speak, but it is covered under one memo. As Planning Commission staff, we thought that was the most efficient use of everyone's time, and these sites are also adjacent to one another along Bishop Road 1, 2, 3. So given the proximity of them and the same nature of the request, we have put these on one memo. And that would be for HCCPA 2407, 2409, and 2413. And with that, I will pass it on. Ms. Carla Llanos is virtual, and she's going to introduce the item, and then Ms. Alexis Myers is going to continue the presentation. Thank you.
Good morning, Commissioners. Carla Llanos and Alexis Myers with Planning Commission staff. Today before you are 3 separate privately initiated text amendments to expand the urban service area. So HCCPA 24-13 is also known as North Bishop Road and County Road 579. HCCPA 24-09, Saffold Road and County Road 579. And then the third is HCCPA 24-07, also known as 5711 Bishop Road. So as Ms. Leinhardt had mentioned, all 3 areas abut each other, and they're running north and south along County Road 579. Each plan amendment is under a different ownership and is considered separate from the other request. However, since all 3 of these amendment areas are in proximity to each other, we just thought it would be just overall better just presenting one memo for all 3. With that said, I'll turn it over to Alexis. She can describe the First Amendment area.
Okay, yes. So the First Amendment, private amendment HCCPA 2407, 5711 Bishop Road, has been submitted to expand the urban service area boundary. This amendment does have a map amendment in progress under HCCPA 2319 that was submitted in the October 2023 plan amendment cycle. The plan amendment was postponed to allow for the urban service area boundary extension that was just submitted with the January 2024 cycle and is being presented for consideration. The subject property is 575 acres, and the existing USA boundary line is the blue line right here. And the aerial is going to be the pink, so it's going to be a 2407 right in the middle right there. Oh, sorry, right there. Yes, so the requested expansion site is shown in pink in the aerial.
Now, the next request is HCCPA 24-09, Saffold Road and County Road 579, which has also requested an urban service boundary area extension. This amendment has submitted a map amendment under HCCPA 24-08. The subject property is 600 acres, and the existing USA boundary line, again, is in blue. And the requested expansion area is shown in that pink where Alexis is pointing at.
Okay, then we have HCCPA 2413, which is located at North Bishop Road and County Road 579, which has also requested an urban service boundary extension. This amendment has submitted a map amendment under HCCPA 2412. The subject property is 505 acres, and the existing USA boundary line is in the blue line. The requested Expansion site is shown in pink in the aerial right up top right here.
Now, for staff to adequately review the proposed amendment, the applicant needs to provide, some of the following. So we requested an analysis of how the request is consistent with the comprehensive plan for expanding urban service boundary, included but not limited to the adopted policy 2.2, objective 3, and policy 3.1, and other applicable objectives and policies of the future land use element. That specifically also they address, expansion of the urban service area. There's certain criteria for it. Now, we also requested a report analyzing the compatibility of the proposed extension with the surrounding future land use pattern. And we also put in some verbiage there in case we need any additional data as requested by Planning Commission staff. Now, staff is asking the applicant to hold at least one neighborhood meeting in addition to what is already required by the procedures manual for map amendments. Additional public outreach requirements for the proposed amendments can be found in Planning Commission staff's memo. Furthermore, since there are map amendments in progress that are directly related to each of the expansion areas, we found that it would be more ideal to pair them together up in the cycle so they can come before the board at the same time. Additionally, Planning Commission staff's memo did indicate that if the board desires and directs a concurrent rezoning for any of these 3 properties, it could potentially result in an extension of that recommended time frame. And it's just based on that we need to coordinate all 3 applications to move forward together. Now, staff is requesting to the board to take action either by a motion to allow each individual application or making a motion on all 3 of them to either accept or take no further action on the applications itself. Now, Alexis and I will be here if you have any questions about any of the 3 areas.
All right, thank you. All right, which applicant wants to go first? Don't be shy. Good morning.
Commissioners, good morning. William Malloy, 325 South Boulevard, Tampa, Florida. I represent the 2407 effort here, which is the middle piece. I'll keep this very brief and high level because we're really here just asking to ask. That sort of puts us at your mercy, but very much at your service too, because I think with these smaller scale efforts, privately initiated, we can work with your staff and with the county-wide application, as a whole that you're studying right now, to really figure this program out, what we need to do, what we need to provide to substantiate this expansion. Let us carry the torch for you a little bit on this. Let us start it. With that, we're happy to answer any questions. Again, I don't want to get too granular with this because this is really an ask for an ask. Thank you.
All right, thank you.
Good morning, Cammie Corbett with the law firm of Hillsborough and Henderson. And I represent Eisenhower Property Group, who is the applicant representative for both the northern and southern portion. We do have separate property owners, so we are asking for these to be considered as separate applications. There are some synergies, but we paid a separate application fee, and we should be treated as separate applications to ensure that we're applying the right standard to each application. Obviously, it will be ongoing together. There will be some overlap. One difference with these 2 applications is the lower property in pink and portion of the green property were part of the council rezoning that you all approved last year. We had extensive community outreach on those applications, and we have a very good working relationship with the Waimama community. We met with them in January. We are going to meet with them again in March, and we will hold a community meeting again and as many community meetings as we need to, just like we did with the council growers application. And so that's one distinguishing factor for these. But again, I think you've already set in motion the necessary tools to look at this. We've actually provided a lot of the analysis that the Planning Commission has requested, and we would ask that you expedite these and process them as expeditiously as possible, because we did file in January, and it's taken us 2 months just to get to this point where we get to ask you to ask. So we would ask that you allow us to move ahead at the first available cycle. And with that, we'd respectfully request you move forward this morning.
All right, this is a public hearing. Would anyone like to speak to the item, either of these 3 items? All right, Commissioner Owen.
Thank you, Mr. Chairman. This is obviously in my district. Mr. Gormley, so what we're talking about with these three parcels were, two of these sites are in the WVR2, right? And then the one in the southeast corner is not in a PD yet, correct?
Correct. All three of these sites are all in WVR2. A portion of 2407, most of 2407 is an existing PD. The northeast corner is not yet in the PD, is not in a PD at this time.
Got it. And only one of them has basically is stated that it's going to be limited to Res 4, correct? Not the other two?
The other two, we have clarified, all three of them do have companion applications that were referenced, and all three of them are seeking Res 4.
Res 4, good.
They're all consistent in what they're seeking.
Yeah, and Commissioners, this is, I think, the area that we pretty much all agreed on should move first in the urban service area expansion. So, obviously, I think all of this makes sense. The only thing I would like to add, and I don't know how, if I can add it to, because, as they stated, it's asking to ask, so we're not making a final motion, but I'll move to authorize staff to allow the amendment to proceed. But I guess my big question is I would like to limit this expansion to Res 4. So is that direction I give you now, or would that be, go ahead.
I think that would be helpful direction, is each of these parcels have a Res 4 companion amendment, but as you noted, the board has approved, have directed us to look at expanding the urban service area for the wider Waimama Village area. So if there was a sentiment from the board that was appropriate for Res 4, that would help with that expansion. That direction we'd take that into, we'd take that direction in looking at expansion of these areas as opposed to some other options of creating new future land use categories or modifying existing future land use categories. So I think these can move forward. The map amendments are separate from this direction,
sure,
but perhaps a separate motion that would reinforce the support for Res 4 for.
So after we dispose of this, I can make a separate motion that future map amendments are limited to Res 4 for.
Yes, I think that'd be appropriate, and that would give us staff direction on how to proceed with the prior board direction.
Okay, then I'll just stick to the motion for now, and Mr. Chairman, if I can make a motion after, to proceed with the amendment for review and begin outreach. Thanks.
I got a motion by Commissioner Owens and Commissioner Wostel. Commissioner Kemp.
Yes, I'd just like to know what is the acreage of these three areas together?
Hi, thank you, Commissioner Carly Llanos again. So each plan amendment area, the first one that we were looking at, 24-07, it's 575 acres, which could produce approximately 2,300 dwelling units. The second area is 600 acres, and it could produce up to 2,400 dwelling units. And the third area, which is approximately 505 acres and can produce up to 2,020 dwelling units. Overall, we're looking at 6,720 dwelling units in the area. However, just note that not all of that density could be achievable, as the area has a lot of environmentally sensitive wetland areas. It's very hard to determine how much the acreage is actually developable at this stage. It's more appropriate for that rezoning stage, where we review the environmental acreages in conjunction with the EPC and the Environmental Department of Hillsborough County. So yeah, that's the answer.
Is it typically considered that you have, do you have a point for, how many cars you have per dwelling unit in an area like this, where the only way you can do is by cars? Because I imagine if you have 6,700 dwelling units, you probably have 2 cars per unit.
I would ask a transportation expert, if we have one here, to come address that particular question. But what I can say is during the map amendment stage, not this text amendment, community and infrastructure planning with Hillsborough County, they do require a traffic study. So that methodology is outlined, and they will analyze that and provide agency comments based on the total potential build out at residential 4. But again, that would be with the map amendment. But the text amendment that we're talking about today, the 3 and the map amendments, not all 6 items, but the 2 couples, they will all travel together in a cycle once they've had their meetings, their community meetings. So you will see the text amendment for the same area along with the map amendment for the same area.
Okay, did you get some information on that?
So from a trip generation standpoint, it depends on what type of residential unit, but generally we look at between 8 and 10 trips per day per residential unit, again, depending on what type of unit.
So you don't have necessarily a car, but you have the number of trips a day.
It's contemplated that those would be vehicular car trips.
Right, no, but I meant like, I would just imagine these are typically 2 cars at least per household.
Typically.
Yeah. So we're talking about 60, this is just this, not even talking about the one before, which was 2,000, but we're talking about here, 6,700 possible dwelling units with, if we do, double that, we're having some 13,000 cars that we're adding out here. As you said, 8 to 10 trips a day per dwelling unit. Do we have any plans on things like, Bishop Road? When are we going to have the information about how these roads are going to be improved? That's already, as we've heard before here, agony, literally out there with the traffic that is hitting those roads, and there's no relief soon, even for everyone who lives there now, not to mention putting down, some 14,000 new cars, some 6,700 new single-family homes in this area, not to mention the area that we just looked at, which is just a small part of that area that we're talking about. So is there anything that we can speak of now in terms of road improvements that are in the picture?
Commissioner, I will say that as projects come in and rezone, we do look at the roads that are being used for access and the condition of those roads, and those that have more than a de minimis amount of traffic on them. We do require that those roads be brought up to county standards, at least to the best extent possible, given the right-of-way conditions, and we do those on a project-by-project basis. Let's identify that at least actually all 3 of these rezonings do currently have some road improvement conditions as part of their PD rezonings. Between the 3 of them have requirements to improve County Road 579 up to 674. So that's currently how we are.
What kind of improvements? Is that just like intersection improvements and some turn lanes and stuff, or is that actually adding total new lanes and redoing the road and doing it? A lot of this traffic is also going almost all of it going east, and some of it going north. And what kind of improvements are?
Yeah, so the improvements on 579 are, I believe, lane widening and adding and improving shoulders on those lanes, as well as pedestrian facilities. It does not, the conditions don't require new additional lanes, but require bringing the existing road closer to county standards and providing, again, pedestrian improvements.
Right, and adding lanes would be the responsibility of this county commission.
It's certainly within the board's purview to look at those type of expansions. The right-of-way on 579 may be a little constrained for a 4-lane facility.
Right, and in the mobility fees, they're not calculated to cover anything like that.
The mobility fees are calculated based on the consumption of roadway capacity and the costs associated with it. So those 8 to 10 trips a day get translated into a portion of road segment, and the attendant cost for that segment is what's the basis for the mobility fee.
Yeah, I'll just say we're so behind on our infrastructure. I haven't even gotten to water or wastewater, parks, fire stations, water pressure for fire stations. And, this is a huge, huge piece to bite off here with 6,700. 6,700, it's like hard to believe, right out there, and adding all that traffic on our already strained infrastructure that, is not there in place. And by the way, we didn't have the impact fees so de minimis before, that those weren't even there, but they don't cover the cost of, doing what we need to do. But at this time, I think it's premature to go forward, so I'll be voting no.
Commissioner Rolston?
I saw Mr. McCoy stand up. Did you need my time? I was going to offer it to you if you had something to add.
First of all, thank you very much, Commissioner. I just did want to add that it's a condition of my existing PD. This is 2407, to improve Bishop Road, make certain improvements to 579, and promote just a bit more of a grid pattern around that PD. Those transportation conditions are already approved, and we're on the hook for them already.
Okay. And I would say, Mr. Gormley, this sounds like a great opportunity for improved Mufasa. And I do think we should say it like Lion King.
All right, we have a motion by Commissioner Owen, second Commissioner Wostel. Please record your vote.
Motion carried 6-1. Commissioner Kemp voted no.
Commissioner Owen?
Thank you, Mr. Chairman. And Commissioner Kemp, I'm almost lifting out of my seat hearing you talk about expansion of roads and infrastructure in East and South County. I promised to work with you. If you all remember, we all voted to dedicate and focus on road improvement in East and South County. So all of that is just absolute music to my ears and something that I've been preaching. And on the mobility...
Not we all. I was not there with you, but...
Okay. The mobility fees... I just want to go a little further on what Commissioner Kemp was alluding to on what we can do with them. You can create new roads with mobility fees, correct, in the sections that are impacted?
Yes, sir. The mobility fees can only be used for capital expenditures and capital expenditures that increase the capacity.
Right.
So certainly new roads, new lanes, improvements to existing roads that enhance the capacity of those roads are all eligible uses of the mobility fees.
Sure, and then through the budget process with road improvements and with prioritizing with development services and public, where we can commit ourselves to roads, road widening and road expansion. So Commissioner Kemp, I'm with you on that. I will work closely with you. So next, I want to make a motion consistent with what we were discussing earlier for moving for future map amendments in this area, particularly the expanded urban service area that we're talking about in South County, that they are limited to Res 4.
We got a motion by Commissioner Owen. Do I have a second? Second Commissioner Wostel. If no other comments, please record your vote.
Motion carried 6-1. Commissioner Kemp voted no.
All right, thank you. E7.
Thank you, Commissioners. Melissa Leinhardt, Planning Commission staff. For the record, this is the final initial consideration memo that we have on the agenda tonight. Following the same process as the previous two items, this is for HCCPA 2411, and this is an urban service area boundary extension along Westlake Drive. Ms. Andrea Papandreou is here virtually and will be presenting this item.
Good morning, Commissioners. Andrea Papandreou, Planning Commission staff. I have not been sworn in.
It's not necessary to swear.
Okay. Thank you. I'm going to go ahead and share my screen. Again, Andrea Papandreou, Planning Commission staff. A private text amendment, HCCPA 24-11 at 15540 Westlake Drive, has been submitted to expand the urban service area boundary, and there is an accompanying map amendment, HCCPA 24-10. So the subject property is 591.61 acres, with the expansion area at 551.03 acres. So the existing urban service area boundary is before you in the aerial in blue, And then the requested expansion site is outlined in pink with the expansion area crosshatched on the aerial before you. So the site is off Westlake Drive and is south of County Road 672. For staff to adequately review the proposed amendment, the applicant needs to provide an analysis of how the request is consistent with the comprehensive plan, including but not limited to adopted policy 2.2, objective 3, and policy 3.1, and any other applicable objectives and policies in the future land use element. A report analyzing the compatibility of the proposed extension with the surrounding future land use pattern, and any additional data requested by Planning Commission staff. Staff is asking the applicant to hold at least one neighborhood meeting in addition to what is required by the procedures manual for map amendments. Additional public outreach requirements for the proposed can be found in staff's memo. Since there is a map amendment associated with this text amendment, the map amendment cannot move forward without the urban service boundary change, and it would be ideal to pair them up in this cycle and for them to be adopted at the same time. If the board desires and directs a concurrent rezoning for the property, and the zoning application is submitted and found sufficient, this may result in extension to the recommended timeframe based on the need to coordinate the overall review. Staff is requesting the board to take action by either a motion to allow the application or a motion to take no further action on the application. Thank you. I'm available for any questions.
Is the applicant here? Good morning.
Again, Jake Kramer with Stearns Weaver Miller. Just like to show one graphic. Staff did a good job of explaining our request. It's similar in a lot of ways to the request that you just heard. The slight difference in context for this particular application is, as you saw earlier, part of this property, part of this ownership as a whole is actually already in the urban service area and is designated as R4. So we're actually going to expand that to cover the entire ownership. And as you can see here, the area we're asking to expand into is completely surrounded by private and public conservation lands. So that acts as a really nice buffer to the existing communities as well as to the other properties in the area. I'm here for questions. I've also got Mr. Reed Fishbach and the Aston family members who own the property if you have any questions. Thank you.
All right, this is a public hearing. Anyone like to speak to the item? Commissioner Owen.
Thank you, Mr. Chairman. And Mr. Gormley, this, I think the applicant just alluded to that this is Res 4, and my prior motion covers this area, correct?
Yes, sir.
Yeah, okay, good. So, yeah, I'll move forward to allow the amendment to proceed and begin community outreach. Thanks.
A motion, Commissioner Cohen, second Commissioner Wostel. Commissioner Cohen.
Excuse me.
Yes.
Sorry to interrupt, but I wanted to make sure that the public comment is provided for in
I asked
addition to
that.
the applicant.
I asked that. Commissioner Cohen.
I wanted to just make a brief comment that really applies to all of these in response to some of the discussion that we've had. You know, none of us are, you know, not aware of a lot of the infrastructure challenges that we face throughout the county, but particularly in this part of South County. But I do want to remind everybody that Tampa Bay Water and Hillsborough County are investing hundreds of millions of dollars in water delivery with the expectation that there's going to be people to pay those bills because the ratepayers are the ones that are on the hook for the expenses that are being incurred down there. I know as part of our CIT discussions, we've seen what the school's plans are for the next few years, and this is obviously an area they're focusing on. And I also wanted to remind everybody that we approved a new wastewater treatment plant a very, very short time ago to directly deal with some of the growth issues in this area. So there's no question the fire station and transportation and road needs are going to be front and center for us. But it's very important while we're voting on these things to keep in mind that much of the public investment that is needed to support this growth has already been made, and those commitments have already been made. So I just wanted to add that to the record, just for the sake of the scope of the entire discussion.
Commissioner Wostel.
Thank you. I was going to bring a different situation up just because 4 years ago I was 3 or 4 years ago, as I was giving a little tour of Waimama, and someone gave me a lot of the history of things that have happened there. And, you know, last night before I went to bed, I snuck in an Aston Farm strawberry, and this morning I had them again. And I would do anything to keep farmers, not only in Hillsborough, but in America, just from a national security perspective and a cheaper cost of living if we don't have to import the food. Everything goes into that. But on that map, if Mr. Kramer, you had a map, I don't know if we have the same map, where it shows them surrounded by land conservation. If we can have that map put back up there, there's an extremely important point I want to make to folks, because again, you've all heard it ad nauseum, and for the past 18 months or so, and you will continue to hear it from my first term, that I am super pro-ag and will do anything to keep them here. But right at the exit, that white area that's on the left hand side of this farmer's property, that's like a pack or production or cooling plant. I don't know. They have lots of semi-trucks. The Aston family has been in Hillsborough forever farming, multi-decades, long before Valencia Lakes was there. And I love and have friends that live in Valencia Lakes. But there is a little piece of land in between the two communities there, right at the exit to his property. And that was supposed to be a connection between 19 and Westlake. Did I get those names correct? Now, that was approved. It was being promised by that developer. It needed to be done for access to the farmer that was already there and had been there for a very long time. But members of that community showed up, and they argued with commissioners that were here back in 2016 at that time, and they got that requirement removed from the developer. So now there's only just a vacant piece of land there. And that critical piece of access to his property, if you see that little sliver through the conservation, I don't know all the details ins and out, but when you make it extremely difficult for a farmer to farm their land, well, then the farmer is likely going to feel like, we shouldn't be here. And their property is their savings account. So while I would do anything to keep them here, I will never vote no against a farmer that feels like they need to sell their land. So I will be supporting the motion. Thank you.
Commissioner Kemp.
Thank you. And again, I'll ask, how many acres do we have here?
Andrea Papandrew, Planning Commission staff. So the total subject property is 591.61 acres, with the request going to residential 4. That would allow for 2,366 total units. However, as Carla Llanos mentioned on the previous application, that does not take into consideration the significant wildlife habitat that is on a portion of the site. So that will be taken into consideration for the rezoning stage when we calculate density, and we work with, the Environmental Protection Commission as well.
Okay, so that's another possible 2,300, maybe twice that many cars, 4,600 cars in a constrained area. Again, we have we have those issues, and I would just say, and I understand your point about the infrastructure, Commissioner Cohen. I don't know how much we built ahead. As a lot of what I know is that we're trying to catch up, even on water and wastewater, because we're not really. When it causes a critical condition, when people can't turn on their showers, like Commissioner Smith had issues with over and over again. I know a lot of it was catching up. We still don't have some 25,000 homes in the urban service area that don't have access to water and wastewater. So we're still going to have those homes looking at connecting, not to mention all the development that's already going on everywhere. But, again, I'll say we have critical needs. We don't have the schools built. We don't have the money to build the schools necessarily. We'll see how that goes. We still don't have the resources to build fire stations, but more than that, we don't have the resources to staff the stations. As we move forward in our, that's going to be an issue. All these things are issues in the future. And when you move forward with this many dwelling units in all these places, and still talking about more, not to mention what we have, and our infrastructure, especially in South County, being what it is, I think it's, I'm not there to move forward to the discussion, but I also think that, we have to really be thinking about this as we go forward and what we're doing in impacting the quality of life, the infrastructure, everything else in these areas. So again, I'll be a no vote.
Commissioner Owen?
Thank you, Mr. Chairman. I'll be quick. And Adam, so we've got 3 new schools going on Westlake, correct? Does that sound right?
Yes, that's correct. Three
Okay,
schools.
3 schools. Yeah, and the problem with schools in more so the South County has really been middle school, that particular school, and there's not a ton of school choice like there is throughout the rest of my district and throughout the county. So I do believe that we have, not necessarily us, and the school board have been addressing the challenges with education. And then the water, I think Commissioner Cohen said well, and kudos to Commissioner Cohen and Wostel for all that you all have done as being a part of that board on coming up with solutions, whether it's the pump station, connectivity through Lithia, and hopefully the future AgMart property would be a wonderful place for our own facility. But I do believe we're addressing those, and I'll just make a comment again. As to the public safety and the roads out there, us as a board, we're going to have a real opportunity this year. And I promise you, I'm going to have plenty of ideas. And we're going to have to make tough cuts in certain places, but we can find solutions to this. And I am just so encouraged by what I'm hearing today on this board, because I am going to give plenty of opportunities for us to make those decisions. Thank you.
All right, we got a motion to approve or to move forward. Got Commissioner Owen, second Commissioner Wostel. Please record your vote.
Motion carried 6-1. Commissioner Kemp voted no.
All right, now we're on the section F of the agenda. Mr. Grady.
Commissioners, the next item is agenda item F1 is rezoning PD 23-0584. This is a request to rezone approximately 2.71 acre parcel on US 41, the south side of US 41, south of Ruskin, and again on the west side of the Little Manatee River. The request is to rezone the parcel to allow for a 7,652 square foot restaurant with both indoor and outdoor seating, encompassing that square footage. Development Services recommending approval. Planning Commission found it consistent, and the hearing officer is also recommending approval subject to conditions. Staff's available if you have any questions. Thank you.
All right, is the applicant here?
Good morning, Cammie Corbett with the law firm of Hillward and Henderson. Again this morning, staff actually showed you all the slides I was going to show you. It's a pretty straightforward request for an outdoor restaurant on the Manatee River. We have all recommendations for approval, and we would have been on consent but for an adjoining neighbor who is trying to use the process to leverage to gain access through their property. So we're here to have answer any questions you might have.
Thank you. Anyone here in support? Any proponent testimony? Any opponent testimony? Planning Commission?
Thank you, Melissa Lighthard, Planning Commission staff. The subject property is located within the Residential 2 future land use category. The site is located in the rural area, and it's also located within the limits of the Little Manatee South Community Plan and the South Shore Area-Wide Systems Plan. The request is subject to commercial locational criteria. While the site does not meet commercial locational criteria, the applicant has submitted a waiver request for review, and the closest qualifying intersection is identified as US Highway 41 and Gulf City Road, which is approximately 1,500 feet away from the subject site, and the subject site falls outside of the 900-foot distance that's required for the Residential 2 category. In the waiver request, the applicant stated that the subject site is an appropriate area for suburban scale neighborhood commercial development. And the waiver request also emphasizes that the proposed restaurant use would benefit the surrounding area, as there are several homes, both mobile homes and single family residential uses nearby. Planning Commission staff has reviewed the commercial locational criteria waiver request, and we recommend that the Board of County Commissioners grant the waiver. The property is not adjacent to any existing commercial uses that would add to the strip commercial. The subject site is located within the limits of the Manatee South Community Plan, as I mentioned. Goal 2 of this plan seeks to protect environmental areas. Goal 5 of the community plan seeks to improve economic opportunities for Little Manatee South, and the proposed outdoor deck helps meet the ecotourism strategy of supporting wildlife observation in a manner that is suitable, given the proposed restaurant includes an outdoor deck. Based upon these considerations, the request is consistent with those goals of the community plan and consistent with that vision. Based upon those considerations, Planning Commission staff finds the proposed plan development consistent with the unincorporated Hillsborough County Comprehensive Plan, subject to the conditions proposed by Development Services. Thank you.
Hearing Master.
I apologize, I'm having some technical difficulties. Report. Apologies for that, having some technical difficulties with the system being slow. The applicant, the zoning hearing master, summarized the application, noting that the applicant is requesting to rezone the subject property to planned development to allow a 6,340 square foot restaurant with an outdoor patio and parking facilities. The subject property does not meet commercial locational criteria, and the applicant has requested a waiver, which Planning Commission staff found supportable, as you heard. The zoning hearing master noted that the proposed restaurant structure height is going to be up to 60 feet, and due to the subject property's environmental features and irregular shape, the applicant is requesting a waiver of 6.01.01 of the LDC, the requirement for an additional 2 feet of setback for each foot of building height over 20 feet. The zoning hearing master, considering the surrounding properties and zoning districts, found the proposal to be compatible and recommended approval of the plan development zoning.
All right, can we have a motion? Motion to approve, Commissioner Owen, second Commissioner Wostel. Please record your vote on F1.
Motion carried 6-0.
All right, F2.
Next item is agenda item F2. It's major mod application 23-0617. This is a request to rezone a 28.3 acre parcel that's located on the south side of Fowler Avenue and north of 301, southwest of the intersection of 301 and Fowler. The request is to add a second development option to the planned development. Again, here's a close-up. Again, it's just on the west side of Williams between Fowler and 301. This is the existing option, and they're proposing to add a second option, which provides for adding the addition of a 94-unit mobile home park and plus 10,890 square feet of mini storage with also boat and RV storage. Planning Development Services found the request approval subject to conditions. The Planning Commission found it consistent with the comprehensive plan, and the hearing officer is recommending approval. Staff's available for any questions. Thank you.
All right, the applicant here.
Cami Corbett again with the law firm of Hill, Ward, and Henderson. Again, staff made a good presentation on what the substance of the application is. This is another one that we would have been on consent, but for we had a gentleman who was under eviction who decided to take the opportunity to sling some mud at the hearing, didn't really say anything relevant about the rezoning itself, but we are here to answer any questions should you have any.
Any proponent testimony? Any opponent testimony? Anyone in opposition? Planning Commission?
Thank you. For the record, Melissa Leinhard, Planning Commission staff. The subject property is located within the suburban mixed-use 6 future land use category. It is in the urban service area and also within the limits of the Thanona-Sasson Community Plan. Future land use element future land use element objective 19 and its associated policies establish guidance for mixed-use development. And the subject site, while located within the SMU 6 future land use category, it is larger than 20 acres. The request includes 3 separate uses and therefore meets the criteria to be considered for a mixed-use density bonus as established by future land use policy 19.3. The existing 19.76 acre RV park is currently approved for 206 spaces and serves as the primary use. The proposed 10.51 acre mobile home park includes 94 units and serves as the second use. The third use includes 1 acre for mini storage and/or boat and RV storage. Therefore, the request meets the criteria to be considered for a mixed-use density bonus. The subject site also meets commercial locational criteria as is located within the required distance of 900 feet from the qualifying intersection of East Fowler Avenue and Williams Road. Future land use element policy 22.5 requires that non-residential uses allow for a transition of use that recognizes the surrounding community character. As depicted on the revised site plan, the request includes the storage uses on the eastern section of the subject site along Williams Road. This is not only reflective of the only existing commercial uses along Williams Road, but it also allows for a transition of use to the west with the proposed mobile home and RV park uses. Goal 4 of the Thanota-Sassa Community Plan seeks to maintain the existing diversity of housing types and styles within the Thanota-Sassa community. The request would allow for a diversity of housing types. The RV and storage uses would also be implemented on a scale that fits the surrounding area character. Based upon these considerations, Planning Commission staff finds the proposed major modification consistent with the unincorporated Hillsborough County Comprehensive Plan, subject to the conditions proposed by Development Services. Thank you.
Hearing Master.
The hearing master considered the applicant's requested major modification of the existing plan development zoning for 2 folios within the plan development. And this would combine the areas designated on the site plan as parcel A and parcel B and allow development of one of the folios with a 94-unit mobile home park and a maximum of 10,890 square feet of mini warehouse and RV and boat storage. The applicant is proposing the existing zoning entitlements to remain as option 1 and the modified entitlements to be approved as option 2. The area subject to the major modification requests will include 3 uses: RV park, mobile home park, and mini warehouse with RV and boat storage. The zoning hearing master noted that the opponent who spoke at the ZHM asserted objections based on potential tree removal, wildlife, safety and security, crime, and density of the proposed development. The zoning hearing master stated that this opponent did not submit to the record competent substantial evidence or expert opinion testimony to support these assertions. No documents or photographs are found in the case record, although he had previously stated that he submitted a summary and photographs. The zoning hearing master concluded that based on the staff recommendations and planning commission recommendations, finding the proposal to be consistent with the plan and surrounding zoning districts, that the proposal for major modification of the plan development zoning is approvable and recommended that it be approved by the board.
Okay, can we have a motion?
Move for approval.
Second.
Motion, Commissioner Meyer, second Commissioner Cohen. No comments, please record your vote on F2.
Motion carried 7-0.
The next item is agenda item F3, rezoning standard 23-0828. This is a request for rezone a 1.2 acre approximate parcel from ASC1 to commercial general with restrictions. Commissioners, you had previously heard this item and it was remanded by the board with the direction for the applicant to consider additional restrictions to address compatibility. Upon remand, the applicant included an additional use restriction, no car wash, but then more importantly, they added a restriction limiting any use of the parcel to a maximum 10 peak hour trips. From staff's perspective, that additional condition significantly limits the impacts of any potential future user on that to something that's very low impact and low traffic generator. Therefore, based on the additional restrictions, the development service staff had previously not supported this, and we had modified our recommendation to be in support with the proposed restrictions. Likewise, the hearing officer also modified their recommendation to approval, but the Planning Commission originally found this inconsistent and is maintaining their inconsistency finding. Staff's available for any questions. Thank you.
Thank you. Is the applicant here? Good morning.
Good morning, Mr. Chairman, Commissioners. Todd Pressman, 202nd Avenue South, number 451, St. Petersburg. Mr. Grady's presented that very well. Your remand served well that we were able to introduce, as Mr. Grady's indicated, a condition that reverses EHM and the zoning department. And I'll also remind you that we've had no one come forward in opposition through the entire process. So with that, happy to answer any questions you might have.
All right, thank you. Any proponent testimony? Anyone here in opposition? Planning Commission?
Thank you, Melissa Leinhardt, Planning Commission staff. The subject site is located in the Community Mixed Use 12 Future Land Use category. It is in the urban service area and also located within the limits of the East Lake Orient Park Community Plan. The applicant submitted a list of proposed restrictions that includes convenience stores with or without gasoline sales, motor vehicle repair, fast food restaurants with or without drive-through, blood and plasma donation centers, recyclable material recovery facilities, and car washes on January 2nd, 2024. The newly submitted restricted list of uses is similar to what was submitted with the original application. It includes car washes on the list of prohibited uses and also includes a restriction on daily trips with a restriction to one access point to the site. Although Planning Commission staff is receptive toward the proposed list of restricted uses, the remaining range of commercial general uses and their potential intensities present significant compatibility concerns with the adjacent residential uses that are located near the subject site. CMU 12 requires non-residential uses to be compatible with residential uses through established techniques of transition or by restricting the location of those incompatible uses. Although the applicant has submitted a list of restrictions and operating hours, the remaining range of CG uses or commercial general uses would still allow for adverse impacts on the residential areas near the site, and therefore the request is inconsistent with this policy direction. The proposed rezoning request is also inconsistent with the vision of the East Lake Orient Park Community Plan. The plan's economic development goal seeks to create commercial development along 56th Street and create a commercial and mixed-use district along Orient Road from Hillsborough Avenue to Columbus Drive. The subject site is not located within either of those areas and also presents significant compatibility concerns. Based upon those considerations, Planning Commission staff finds the proposed rezoning inconsistent with the unincorporated Hillsborough County Comprehensive Plan. Thank you.
Thank you. Is there a hearing master?
The zoning hearing master considered the application on remand at the January 16th, 2024 zoning hearing master hearing. The zoning hearing master considered the applicant's request for rezoning to the commercial general restricted zoning district. The property is 1.2 acres in size, currently zoned ASC 1 and designated CMU 12 by the comprehensive plan. The parcel is located within the urban service area in the East Lake Orient Park Community Plan. As Ms. Leinhardt explained, the Planning Commission staff does not support the rezoning request as it is found to be incompatible with the surrounding development pattern. The zoning hearing master concluded that the request for commercial general with the applicant's proposed restrictions that prohibit certain commercial land uses is not compatible with the surrounding land uses, which include an institutional use to the west, townhomes to the south, and single-family residences to the north and east, given the remaining CG permitted uses that are available to be considered for the property under the code. The longstanding commercial use on the subject property zoned ASC 1 is not justification for a rezoning to commercial general restricted that would permit a wide range of commercial land uses incompatible with the surrounding area. The zoning hearing master therefore concluded that the application to commercial general restricted is incompatible with the development pattern in the area, with the code, and with the plan, and recommended denial.
Point of order on that, yeah.
I think that's not the right one.
Yes, Mr. Chairman,
Hold on, Mr. Pressman.
I'm sorry. I'm so sorry about that. I have the two out of order.
Please don't read it again.
Okay, so to conclude, that zoning hearing master on remand concluded that there was approval merited by the changed proposal of the applicant.
All right, thank you. Can we have a motion?
Move for approval.
Second.
Okay, we got a motion to move the zoning hearing master recommendation of approval. Second by Commissioner Owen. Any other comments? If not, please record your vote.
Motion carried 7-0.
Thank you. Next item.
The next item is agenda item F4, rezoning PD 23-0622. This is the request to rezone approximately 8.825 acre parcel that's located between Lynn Road and Linebaugh Avenue west of Anderson Road in the greater Carrollwood, Northdale area. The request is rezoned from AS1 to a planned development to allow for 79 townhomes. Staff Development Services is recommending approval. Planning Commission found it consistent with the comprehensive plan, and the hearing officer is also recommending approval. Staff is available for any questions. Thank you.
All right, the applicant here. Good morning, sir.
Good morning. I'm John LaRocca, agent for the applicant, representing this case this morning. As stated, the application is for in this case, a 79-unit townhome community that's located off of Linebaugh Avenue with access onto Lynn Road to the north. It's a gated community, a rezoning from AS1 to PD. It's been thoroughly vetted through the process with recommendations of approval with conditions by staff and the hearing master, along with being found consistent by the Planning Commission. We agree with all conditions of approval, and I'm here to answer any questions.
All right, thank you. Anyone here in support of the application? Anyone in opposition? Planning Commission?
Thank you. For the record, Melissa Leinhard, Planning Commission staff. The subject property is located within the urban service area and also within the limits of the greater Carrollwood-Northdale Community Plan. The site is located within the suburban mixed-use 6 future land use category. Vacant and single-family uses are currently located on the subject site, and additional single-family uses are located to the west, north, and east. There's a vacant public institutional property owned by Hillsborough County that also abuts the site on the eastern boundary. Light commercial, light industrial, and heavy industrial uses are located south and southeast of the site and are concentrated around the intersection of West Linebaugh Avenue and Anderson Road. The area directly abutting the subject site is mostly residential in nature, with notable industrial and commercial uses located to the south. The application includes a flex request under future land use element policies 7.3 and 7.4 for the northern portion of the site. The request is to flex the residential 9 category that is located directly to the east. In addition, the application includes a request for a density bonus for infill development on the southern portion of the site in accordance with future land use element policy 23.5. The request meets the intent of the flex provision and the density bonus for infill development. The increase in density would result in a development pattern that is compatible to the existing zoning and development patterns in the immediately surrounding area. And based upon those considerations, Planning Commission staff finds the proposed plan development consistent with the unincorporated Hillsborough County Comprehensive Plan, subject to the conditions proposed by Development Services. Thank you.
Hearing master.
The zoning hearing master considered the applicant's request to rezone the subject property to plan development to allow development of 79 residential townhome units. The applicant is seeking to use the flex and infill density bonus provisions to achieve the proposed density of 9 units per acre over the subject property. The applicant's request was found to be consistent with the comprehensive plan and with the land development code based on consistency with the surrounding development pattern. The zoning hearing master recommended approval.
All right, thank you. Can we have a motion?
So moved.
Approval. Motion, Commissioner Kemp, second, Commissioner Owen. No comments, please record your vote.
Motion carried 6-1. Commissioner Hagan voted no.
All right, Next item.
The next item is agenda item F5, major mod application 23-0881. The request is for a major modification of existing PD to modify 6.35 acre portion PD of the PD to convert current approvals from office to 90,600 square feet of mini warehouse uses. This is on the west side of US 301, south of Causeway Boulevard, and north of Falkenberg Road in the Greater Palm River area. Based on provisions of single-story structures on the western half of the property in closest proximity to residential single-family development, along with required buffering and screening. Staff did find the request approval with conditions. The Planning Commission found it consistent with the comprehensive plan, and the hearing officer recommended approval. Staff is available for any questions. Thank you.
All right, is the applicant here? Morning.
Good morning. Julia Mandel with the law firm of Gray Robinson. I'm here on behalf of the petitioner. As you've heard, we have recommendations from staff, the Planning Commission, and the Zoning Hearing Master regarding this application. There is no one who appeared in opposition at the Zoning Hearing Master, but I believe there's a letter in the record. We feel like we've complied with all the requirements and all of the concerns that have been raised within that letter, and we are agreeing to all the conditions, and I'm here for any additional questions you should have, and would appreciate your support. Thank you.
Thank you. Any proponent testimony? Anyone here in opposition? Planning Commission?
Thank you. For the record, Melissa Leinhardt, Planning Commission staff. The subject site is located within the urban service area and also within the limits of the Greater Palm River Community Plan. Most of the subject site, approximately 6 acres, is designated as urban mixed use 20 on the future land use map, and the remainder of the site, which is about 0.28 acres, has a future land use map designation of community mixed use 12. The proposed self-storage buildings are compatible with the existing character of development in the area, as it's located off a principal arterial roadway with light commercial and apartment buildings along the corridor. The proposal meets the intended intensity as it allows for a 0.5 FAR for the 0.28 acres in the CMU 12 category and a 1.0 FAR for the 6.07 acres in the UMU 20 future land use category. The request includes a maximum proposed FAR of 0.80. The proposal is also consistent with future land use element policy 13.3 as it relates to environmental considerations. The subject site abuts a single-family detached residential neighborhood to the south. As a compromise to address compatibility concerns from the single-family residences, as well as mitigating for wetland impacts, the applicant has proposed 1-story single-family storage building in the rear and 1 3-story storage building at the front of the property along US Highway 301. The building in the rear far exceeds the setback requirements, and there is an existing vegetated buffer between the single-family development and the subject site that will be required to remain. The proposed rezoning therefore meets the intent of Objective 16 of the future land use element and its accompanying policies related to compatibility. The subject site also meets the vision for the Greater Palm River Community Plan, which encourages new development to be compatible with the surrounding intensities and densities at appropriate locations. The plan also promotes commercial development at scales that reflect the character of the surrounding community, and the proposed self-storage use at this location is reflective of the surrounding land use pattern and is also appropriate for the UMU 20 and CMU 12 future land use designations. Based upon those considerations, Planning Commission staff finds the proposed plan development consistent with the unincorporated Hillsborough County Comprehensive Plan, subject to the conditions proposed by Development Services. Thank you.
Hearing Master.
The zoning hearing master considered the applicant's request for major modification to existing plan development 88-0084 to reconfigure the building envelope, reconfigure a parking layout, and allow 6.35 acres to be used for a mini warehouse facility with up to 90,600 square feet of gross floor area. The zoning hearing master noted that the general area surrounding the subject property consists of a mix of single-family and multifamily residential uses, office, retail, and warehouse uses. Adjacent properties include single-family residential subdivision to the west and south, multifamily to the south, multifamily across South US 301 to the east, an office use, and a multifamily apartment community to the north. The zoning hearing master noted that the Development Services Department staff report concluded that the applicant's site plan design, including buffers, building setback, and height limit, mitigate the potential impacts to neighboring residential properties, and staff found the proposed modification to be compatible with existing uses, zoning districts, and the development pattern in the area. And based on this, the zoning hearing master recommended approval.
Commissioner Owen?
Thank you, Mr. Chairman. And I just want to make a comment that I really want to commend the applicant on this. I think there was just one complaint, right, Mr. Gorman, with that property behind, and it had to do with height, and they made the concession to lower it to 1 story in the back, but 3 in the front. So I don't know who the applicant is. I just really want to commend them for working with the one property owner on this. So I'll move for approval.
A motion to approve, Commissioner Owen, second, Commissioner Cohen. No other comments. Please record your vote.
Motion carried 7-0.
Next item.
Next item, Commissioners, we have 2 related items, G1A, which is a vacating petition 2310, and then G1B, which is rezoning petition 23-0714. Carrie Allen with Infrastructure Services will provide a presentation on the G1A portion of the related items, and I'll provide a brief overview of the rezoning request 23-0714. I believe the board can, after completion of the 2 presentations, vote on these 2 items together.
Good morning.
Good morning again, Commissioners. For the record, Carrie Allen, Facilities Management and Real Estate Services Department. Item G1A is vacate ID V230010. This is a petition by Sims Family Partnership Limited to vacate portions of an unimproved platted public rights-of-way within the plat of Fairmont Park as recorded in Plat Book 21, page 40. The petitioner has submitted this request to create a contiguous parcel and intends to replat the property into a residential subdivision. Certain platted rights-of-way immediately north of the vacate area have previously been vacated, as depicted in green on the map, thereby limiting future connectivity. The proposed vacate area is located southeast of U.S. Highway 41 and north of 21st Avenue West in Ruskin, and consists of approximately 148,000 square feet or 3.41 acres. We did receive 1 reviewer objection from the Planning Commission. They only object to vacating 1 of the 7 right-of-way vacate areas, which is depicted in blue on the map. They are stating that this right-of-way could provide a potential future access point to the South Shore Community Resource Center, which is to the north. Staff makes note of the Planning Commission's finding that the proposed vacating is inconsistent with the Hillsborough County Comprehensive Plan, but upon review believes that a new access point to the Resource Center is not necessary. Based on all of the county departments having no current or foreseeable need for the subject right-of-way, staff recommends approval of this petition request.
All right, this is a public hearing. Would anyone like to speak to this item?
Cami Corbett with Hill, Ward, and Henderson. Just real quick for the applicant, I'm going to go into, when I do the zoning presentation, some of the reasons why not only is it reasonable to ask for access here, it's not practical, and I'll address that in the zoning petition, but would respectfully request your support of this.
All right, would anyone else like to speak to this item? Or if not, we're going to defer voting until we hear the rezoning. So, Mr. Grady, do you need to introduce this?
Yeah, the next portion of the agenda is for this related items, G1B. This is rezoning standard 23-0714. This is a request to rezone a 15.85 acre parcel in the Ruskin Community Plan area from AR, and RSC 6 to RSC 9 with restrictions. Commissioners, the restrictions address compliance of this project with the Ruskin Community Plan policies and design guidelines that are outlined in the Land Development Code. They include the limitations on lot sizes and lot widths in accordance with the requirements in the Land Development Code, and more importantly, regarding compliance with policies about maintaining the grid pattern, the historic grid pattern that's within the Ruskin community. The applicant agreed to providing for connectivity to Second Street Southeast, and also east-west connectivity through the project, and limitations of no cul-de-sacs or gates on the project. Based on those restrictions, staff did find this approvable and felt that it did comply with both the design standards in the code and the applicable policies in the comprehensive plan. Likewise, the hearing officer also recommended approval with those restrictions. As noted in the presentation on G1A, for the same reasons, the Planning Commission that outlined regarding access to the South Shore Community Center, Planning Commission did find overall the request inconsistent with the comprehensive plan. Staff available for any questions. Thank you.
All right. The applicant here.
Cami Corbett with Hill, Warren, and Henderson. If I could just get my presentation. Or not. I don't know how to get that up. I'm just going to use Elmo. Going to skip some of the same slides. Request for RSC 9 restricted to comply with the Ruskin Community Plan. We're complying with all of the requirements of that plan. Okay, there you go. Development location you've seen. Request. Really what we're dealing with here is the Planning Commission's objection to compliance with the Ruskin Community Plan. And the policy language in the community plan says the development should continue the traditional grid street pattern in Ruskin to the greatest extent practicable. It doesn't say for any reason or at all costs. It says if it's practicable. And what does that mean? Is it feasible? And you just heard real estate talk about all of the vacations that have already occurred in the area that make this impractical. But also, again, this is the surrounding area. That's the vacate. So this map shows what the connectivity that the Planning Commission required. The blue arrows to the east and the west. They wanted the one arrow further to the west. We're providing that connection to the east. And then we have the one area where we're not providing a connection whatsoever. Again, this is an aerial of the subject site, and you can see in this yellow circle where they wanted the connection. And then this is the actual boots on the ground, what's there now, and how is this property being utilized. It is not a street grid. This is a community center. This is parking. This is handicap parking for the community center. This is just north of the property line. Again, this is looking south. You can see it's heavily treed, in use as a parking lot. More photos. And then this is actually looking west, and you can see this is a driveway near the infant center. This is not suitable for public roadway improvements. This is where children play. This is not something that makes any sense whatsoever. Again, this is the Ruskin Infant Center Child Development. You see the playgrounds there. You see the one-way signs directing traffic through the driveways. And again, these are just internal driveways to the community center. There is no roadway grid here. I think that it is definitely not practicable to provide that connection. And then also to the extent that one wanted to make a connection to the north, all the way over to the east, there is an unvacated right-of-way that is outside the limits of what we are requesting. Let me go down and show you. See where that blue arrow is pointing to the east? We are not vacating that right-of-way that's to the east. So should anybody want to continue a street grid in this area, there is still right-of-way available to do that. It just wouldn't go through the rear of the community center. And as staff indicated, we otherwise have recommendations for approval from Development Services and the Zoning Hearing Master, and we're here to answer any questions you might have.
All right. Any proponent testimony? Any opponent testimony? Planning Commission?
Thank you, Ms. Melissa Leinhardt. For the record, the subject property is located within the urban service area and also within the limits of the Ruskin Community Plan and the South Shore Area-Wide Systems Plan. The future land use category of the subject property is residential 4. Goal 5 of the Ruskin Community Plan states that the developments should continue and or replicate the traditional grid street pattern. Based upon this adopted policy direction, the proposed rezoning has been found inconsistent. For this proposed rezoning, the applicant has stated in their narrative that they will provide connections along the western boundary to 1st Street Southwest and along the eastern boundary to 3rd Street Southeast. Additionally, internal cul-de-sacs and gates will not be permitted. No connections are proposed north or south. Planning Commission staff recognizes that there is no right-of-way further northwest of the site towards 14th Avenue Southeast. However, there is an opportunity to provide a connection north from 2nd Street Southeast to the South Shore Community Resource Center located directly north of the subject site. Additionally, there are up to 4 potential connections to the south. There are opportunities to replicate and provide a grid pattern south of the site by connecting to 16th Avenue Southwest. While it is currently being used as a drainage ditch, Planning Commission staff has not received any documentation from Hillsborough County staff stating that 16th Avenue Southwest cannot be a viable future roadway connection. The proposed rezoning does not provide two connections to 16th Avenue Southwest to provide the necessary grid pattern as outlined in the Ruskin Community Plan. The proposed rezoning would conflict with the continuation of the neighborhood's grid network of streets and would limit the ability to connect neighborhood serving uses. The potential connections to 16th Avenue Southwest and 2nd Street Southeast will establish a grid pattern in the area, which would connect to the existing grid south of the site on 17th Avenue Southeast and 18th Avenue Southeast. Staff recognizes the applicant's willingness to connect east to 3rd Street Southeast. However, since 3rd Street Southeast has not been constructed to the west of the site, a connection on 2nd Street Southeast would allow an established grid pattern in the area and provide a connection to the community resource north of the site. Additionally, a standard rezoning does not require a site plan or allow for conditions of approval for staff to fully evaluate how the grid pattern would be maintained in Ruskin. The petition is therefore inconsistent with the policy direction established by the future land use element, the mobility section, and the vision of the Ruskin Community Plan. And based on those considerations, Planning Commission staff finds both the vacating and the proposed rezoning inconsistent with the unincorporated Hillsborough County Comprehensive Plan. And I'll apologize, that sounded a little like Dr. Seuss, but I was trying to read it clearly. Thank you.
Hearing master.
The zoning hearing master considered the applicant's request for rezoning to the RSC 9 restricted zoning district. The property is 15.88 acres in size, currently zoned AR and RSC 6, designated residential 4 by the comprehensive plan, located within the urban service area and the Ruskin Community Plan. The zoning hearing master noted that the applicant has proposed restrictions which ensure compliance with the Ruskin Community Character Guidelines. The restrictions proposed address minimum lot size, minimum lot width, maximum density, and connectivity standards. Additionally, internal cul-de-sacs and gates are prohibited. As you heard from Ms. Leinhard, Planning Commission staff does not support the rezoning request. The Development Services Department, however, including Transportation Review, support the requested application. The zoning hearing master concluded that the proposed rezoning to RSC 9R restricted is compatible with the surrounding area and development pattern and recommended approval.
Commissioner Owen.
Thank you, Mr. Chairman. I feel like I'm on the matrix in this one. So, I've looked at this in depth, and Melissa, the way that I look at this, when I look at the map, if you want to pull it back up, that shows the green, the vacations that have already taken place, to me, because it sounds to me like you all agree that it's in compliance with the Ruskin Community Plan, that it has, they're agreeing to no gates, to extend 2nd Street, and no cul-de-sac. So to me, the big issue that I see with you all is that blocking off or lack of ability to have connectivity to a community center that is to the north. But when I look at it, I see that with the vacancies that already taken place, that I don't see that happening anyways, but you were kind of giving other solutions, and you went through that pretty quick. Can you just tell me again that solution to just the as is now? Because I see the green, and I don't see the connectivity that you're talking about to the north. So,
Thank you for that question. I'm happy to clarify. So, and also thank you to real estate. This is a great graphic that really illustrates everything that's kind of going on with this one. So the blue crosshatch area is the
Yep.
one connection that we would like to see maintained. The rest of the vacatings we understand and are necessary to develop the site for residential. But the county site is the property that's located directly to the north, kind of like the northeast of that blue crosshatch area. And there is access to that site if you look underneath the aerial. That portion of the right-of-way would still touch that property. So there still would be potential for access. You don't necessarily need that east-west connection that's already vacated to the north. The name of that is escaping me right now with all the southeasts and southwests. And the other thing that I would just add to the conversation is that it's very difficult with a standard rezoning when you don't have a site plan,
Yeah.
to look at the actual grid pattern and the implications more from a larger community perspective, especially when you have such strong language in a community plan about maintaining the grid and promoting the grid moving forward with new developments. So we met with real estate so many times on this,
Yeah.
and we kind of went round and round a little bit. And again, we understand the practicality of the other vacatings, but it's really that one in the blue crosshatch that we felt could really be a community serving interest. And there's no documentation saying that that cannot ever be a connection. So we didn't see the harm in keeping that one. And to Ms. Corbett's point, the right-of-way that is kind of to the east of that easternmost red line, that is not in this site. So at this point, we're not really talking about that tonight, and we really don't have control over that as part of this discussion. So while we're happy that that's still there, that's not really part of the discussion today, so we really wanted to focus on what we could do as part of this application.
Sure. Thanks for that explanation. And I know, Adam, you and I had talked about this issue, and I know that a lot of your approval is based on that, on the prior vacations. Can you kind of give your input on it too?
Yes, we looked at the prior vacatings as basically creating an impediment to making future connections as well as what's existing on the site. I think the pictures that were shown illustrated pretty well that that area is already developed. It's already developed with parking and uses and on-site circulation to support the community center and Head Start facility, which really is not compatible with having a roadway run through that project, or even a connection to the back side of the project that is oriented more towards the Head Start the Head Start use that's on the south side of the county site. So for that reason, we didn't feel it was practical really to make a connection or to require a connection to that county facility.
Great. Thank you both for your input. I'm going to move for approval. Thanks.
I got a motion to approve G1A and G1B. Do we have a second? Second, Commissioner Wostel. Commissioner Kemp.
I'll just say with the analysis and the one limitation with the blue crosshatch, I thought that was interesting to see, and I'm glad that you looked at it so closely and went back and forth about it. I'm not all convinced from what I saw with the community facility there, the county facility, that won't be rebuilt and changed, and that there should be and could be access to that. I would really like to maintain that one point. The other vacations, I think, do make sense. And of course, the vacations to the north, I mean, that's a water body. So and people's property on the water. So I can see where those were done. But in continuing the grid in this one place, I think it is significant, especially since it's a community facility, Hillsborough County facility. So I'll vote no if we go forward with this. I would really like a modified, I could approve a modified one that just, where that one crosshatch that was raised continues to be a connector. I guess I'll make that motion and see if I have a second or any support for that.
A substitute motion by Commissioner Kemp. Do we have a second?
I'll second that.
Okay, second by Commissioner Cohen. Any discussion on the substitute motion? If not, please record your vote.
Motion failed 5-2. Commissioners Cameron Cepeda, Hagan, Myers, Owen, and Wostel voted no.
All right, go to the original motion by Commissioner Owen, second Commissioner Wostel. Please record your vote.
Motion carried 6-1. Commissioner Kemp voted no.
All right, we're going to adjourn our land use meeting, and then we're going to reconvene as the EPC board. So we are adjourned.
Oh, well.
Go ahead.
Good morning. I'd like to call to order the Environmental Protection Commission special meeting. We are opening a special meeting of the EPC to consider Tampa Bay Water's application for a water use permit. Do we have any public comments? None?
It's on now. Commissioner, there's no online signups or walk-ins, so as of now, no public comment.
Okay, then we'll turn it over to you, Director Lawton.
Thank you, Commissioner, and I would like to thank, obviously, all of you, Bonnie Weiss, George Cassidy, and Adam Gormley, for allowing us to incorporate this meeting at the end of their meeting. This is very helpful to us. Also, today I have with me Rick Marati, who is our General Counsel, and Allison Amram, our Senior Hydrologist, to answer any questions that you may have. So I have briefed all the commissioners. I'm going to run through 7 quick bullet points and then ask for a vote. Pursuant to an interlocal agreement, Tampa Bay Water must wait 30 days to file a water use application unless the county and EPC vote not to arbitrate. Tampa Bay Water Board voted on February 26 to submit an application to SwiftMud to modify the Baum Farm water use permit to allow for a total withdrawal of 775,000 gallons per day. Tampa Bay Water has requested the EPC vote not to arbitrate the application for the water use permit modification so it can be submitted to SwiftMud sooner. Hillsborough County BOCC just voted on the land use consent agenda this morning to not arbitrate this matter, and we are bringing the same item to you as EPC. The wells are in the Baum area of southern Hillsborough County, and the proposed modification will provide additional public water supply to southern Hillsborough County. The proposed withdrawals come from existing water use permits previously owned by private entities that have agreed to transfer them to Tampa Bay Water for public supply. Tampa Bay Water will use 10% less than originally allocated to the third parties to meet SWCA criteria and create a net benefit. EPC staff recommends not to arbitrate this application, and we're available for questions.
Commissioner Cohen.
I just wanted to comment that this is all a result of Tampa Bay Water doing everything it possibly can to provide additional short-term water supply to southern Hillsborough County so that it's going to take a couple of years for the new pipeline and the new facilities to be totally built out. And this really represents a very proactive step on their part, and we've been very appreciative of all those efforts.
Any other comments? We have a motion.
Move approval.
We have a motion and a second by Commissioner Cohen, second by Commissioner Watson. Please record your vote.
Motion carried 7-0.
Thank you, commissioners, and we'll see you at our next meeting in April. Thank you again.
Thanks, everyone. Have a good day.
You too.